Hey, what up, Hector? How's it going? What up, nurse? What up, Southside? All right, all right. Yeah, it's gonna be Polk County.
All right, good afternoon, everybody. Judge Stamey here at the Polk County Courthouse. I can see South County's joined us. Central, the camera's not working yet, so while we're waiting for them to come online, do we have any interpreter cases from South County?
No, we do not, sir.
All right, thank you. Let me confirm with Central if they have any interpreter cases.
We have one so far. We have about 15 coming in through the door.
Okay, you still need a few more minutes. That's fine. But
One
But as
Spanish
far
so
as-
far.
Oh, damn, we got a full house today.
one
And one Spanish.
Hey,
Okay,
what
not
up,
a problem.
Sarah?
We'll give you a minute to get everybody in place. Ms. Hernandez, once we get everybody in place, I'm going to read the advisory in English. When I'm done, could you please read it in Spanish?
Yes, Your Honor. Good afternoon.
Good afternoon.
What
to
up,
you.
Raven? What up, Kelsey?
While we're killing some time, why don't you raise your right hand, Ms. Hernandez? We'll make it official. Do you swear or affirm that you will well and truly interpret Spanish into English and English into Spanish to the best of your ability on the causes now pending before this court?
Yes, Your Honor, I do. Clarissa Hernandez for the record.
Thank you.
Hey, thank you for that daily heart. Hardly appreciate you guys. See, I'm just setting everything up right now, so we're ready. Hey, what's up? What's up, Chad? How's it going? What's up, Miss
Well,
Perez?
Go ahead and tell me what case y'all are here on, and I'll pull it out, and we could even possibly do it before.
I'm
the
Jonah
advisory.
Dreyfus,
Hey,
DREYFUS.
Okay. Don't mind doing that once we get everybody in place to get you in the way. Mr. Tribble, who are you here on?
Your Honor, I have three today.
Okay,
Giuliano Castagne,
with the C.
Castagne.
Okay,
what up,
We
Flaco?
also
How's it
have
going?
David Perez Valdez.
Rez.
All right, I'm just making some minor adjustments here.
Okay, Mr. Perez Valdez.
And then I have an interesting name. We're just going to say Yodhe Wahe is the last name. First name is pronounced Judah, not the typical spelling.
Come
Yeah,
again?
I think he's our last one on our docket, so that was easy to find. So, okay. Get everybody in place.
All right, all right, all right. So, hey, today is Thursday. It's one day closer to Friday, if you will. Let me see. What's up, Jess? It's on your birthday. Happy birthday to Jess, if you
I'll
will.
go ahead and read the advisory. I think some of your cases have some significant charges, so I'm absolutely taking it.
Oh, that's right, Hector. That lady is coming back
Y'all let me
today.
know when everybody's in place and we'll get started.
We're ready, Judge.
All right. Good afternoon, everybody. Judge Stamey here at the courthouse. This is your first appearance hearing. A first appearance hearing has four purposes and four purposes only. First, I will advise you of the charge or charges that have been filed against you. Second, I will ask you if you have an attorney representing you. If you have hired an attorney and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing that hearing until tomorrow. If you postpone the hearing until tomorrow, it is your responsibility to contact your attorney to let them know you will have court tomorrow. If you wish to move forward without your attorney present, we can do that.
What up, Ann?
If you do not have an attorney,
What up, honey?
I will ask you if you can afford one. If you can't afford one, we'll
Can't
make a
even
note of
afford a
that
gas right
and
now,
we'll
Your
hold the
Honor.
hearing. If you cannot afford to hire one, and if you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending you filling out a formal application at some point in the future. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those challenges. And finally, I will review your bond or bonds or any other release conditions with you to determine if any changes are necessary.
What up, Captain?
Be aware that this court places you on pretrial release today, regardless of whether it is straight pretrial release or as a condition of your bond. The conditions announced in court today go into effect immediately, meaning even while you remain in custody. For example, you are told to have no contact with a certain person, let's just say the alleged victim, and you called the alleged victim from the jail before you are released, you are in violation of your pretrial release conditions. Throughout this entire process, you have a constitutional right to remain silent.
Anything
If
you
choose
say,
not to remain
anything will
silent,
be used against
anything
you in a
say
court of law.
Can be used against you.
What
Everything
up,
that is
Syfe?
being said where I am located at the courthouse, as well as where you were located at the jail, is being
What up, Adam?
recorded. There's an assistant
Bueno,
state
bueno.
attorney
What up,
present
Smog?
listening to everything that is being said. So do not say anything about the crime itself. Please keep these rights in mind as we go through the process, and please step forward as your name is called.
Polk County,
Buenas
Florida.
tardes. Les habla el juez Stamey y estamos hoy aquí para una audiencia de primera comparecencia. Una audiencia de primera comparecencia tiene únicamente 4
Amber, thank you.
propósitos.
Highly appreciate you,
Primero, le
Amber.
informaré sobre el cargo o los cargos interpuestos contra usted. Segundo, le preguntaré si ya usted tiene un abogado que le represente. Si usted ya
Sabrina,
ha
thank you.
contratado a su abogado privado y él o ella está presente con usted en esta audiencia, hablará por usted. Si su abogado no está presente en esta audiencia, usted tiene la opción de proceder hoy con su audiencia o de posponerla para mañana. Si usted decide posponer
What up,
la
Cindy?
audiencia,
Welcome back.
será responsabilidad suya comunicarse con su abogado y hacerle saber que usted tendrá una audiencia. Nadie podrá hacer eso por usted. Si usted desea proceder sin su abogado presente, puede hacerlo. Si usted no tiene un abogado, yo le preguntaré si tiene los medios económicos para contratar uno. Si es así, haremos una nota de esa información y procederemos con la audiencia. Si usted no tiene los medios económicos suficientes, yo puedo asignar a la oficina de la Defensoría Pública para que le represente a usted, esperando que usted llene una solicitud. Usted tiene derecho a que su abogado esté con usted antes y durante cualquier interrogatorio. Tercero, yo me ocuparé de resolver cualquier recusación presentada con respecto
What up,
al
Frank?
motivo probable de su delito.
What up, Tavo?
Finalmente, revisaré con usted
Or
las
Tavo?
fianzas
Tavo.
u otras condiciones de libertad
Allison.
condicional que hayan sido impuestas hoy, sin importar si es una libertad condicional sin pago de fianza o las condiciones de su fianza. Las condiciones que el juez anuncie hoy entran en efecto
Hey, Paul G, thank you.
inmediatamente,
Highly appreciate for
aun
those
cuando
300
usted se
minutes.
encuentre bajo custodia.
Amber, thank you once
Durante
again.
todo este proceso usted tiene el derecho constitucional de guardar silencio. Si usted elige decir algo,
Tucson, I got it on my
cualquier cosa que usted diga
other
puede
stream
ser
on YT.
utilizada contra usted. Todo lo que se diga donde yo me encuentro, así como donde ustedes están, se está grabando. En la sala del juzgado se encuentra presente conmigo un fiscal asistente del Estado, escuchando todo lo que se dice, de manera que, por favor, no diga nada sobre el delito en sí. Sírvase tener estos derechos presentes en medida que avancemos por el proceso. Por favor, cuando se llame su nombre, colóquese frente al podio. Gracias. Thank you, Your Honor.
Hey, I'm doing pretty
Thank you,
good.
Mr. Hernandez. Mr. Hernandez, hold tight one second. I have a couple attorneys here with me. I'm going to try to get out of the courtroom real quick. Let's call up Jonah Dreyfus.
Jonah Dreyfus. Sounds like an actor's name. Come on down, Jonas, wherever you're at.
Dreyfus or Dreyfus? Of course, he's in the back row.
Or doofus, or doofus,
Enter
if
that
you
for us for
will.
the record.
Somebody's gonna say, but I can't see him. He's too small.
Good afternoon, sir. You've been charged with domestic violence battery,
Awa.
tampering with a witness, and domestic violence false imprisonment. I gather you're representing him, Mr. Clone.
Yes, Your Honor.
Okay.
What up, Tweety? Hey, what up, Shannon?
Sir, I've looked over for you and everybody else sitting there at the jails. I've already read everybody's affidavits. I took the last couple of hours and did it back in my office. So having done that previously, I'm going to find probable cause for your 3 charges. I'm going to set your bond on the false imprisonment at $5,000.
Hey, thank you, Hector.
Bond on the tampering with a witness at $2,500, and the domestic battery at 25 for a rounded off total of 10,000.
Wow. Patrick,
Cash
thank you.
surety. Sir, if you're able to post those bonds and you are at some point released.
What up,
you'll need
Chris?
to check in with pretrial release services because you're going to be supervised them. The bonds for your pretrial. Sign up with them in person, calling that office on date is Thursday, so we'll say Thursday. You have all the standard conditions that everyone has, plus the following special conditions. You are not allowed to have in your possession any firearms, guns, weapons, ammunition, or knives, and you're not allowed to have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her home, her vehicles, wherever she works, or where she goes to school. It doesn't appear as though y'all reside together, so there's no reason to go back to her place. All right, sir. Any questions? Or
Hey, Patrick, thank you.
Have a
No
good
parole
one.
hearings today.
We'll be in touch.
What up, Melissa?
Dribble, jump up here. We'll get you out of here.
Hey, Your Honor, can we please call one out of order? We had one that was being an issue and he's got an escort to take him back.
This might be
All
good,
right.
guys.
Just call them up. Tell me their name. Call 'em
Get the
up.
Last name's
tasers
gonna
ready.
be Jones, first name Darian, Derian.
Get the taser
Well,
ready.
We're getting him out of the
Yeah,
cell.
just for now or future reference, if you got anybody that's
Problematic.
Even in court, even though I'm here and you guys are there, this is court. If
Tase
I got
him.
Somebody disrupting court, by all means, if I can see it, then we're gonna have a contempt hearing and we'll decide whether to hold them in contempt and put them in jail for 6 additional months. All right, tell me this gentleman's name one more time.
Damn, they got
Last name is
5 deputies.
Jones, first name Darian, Derian.
All right, Mr. Jones, I think what y'all had court yesterday for Mr. Jones, but there was a additional charge that wasn't addressed yesterday. Does that sound right? So it looks like it
Yeah,
was.
20 and 21, you both got 150.
Hey, turn down
Yeah,
that
Mr.
microphone.
Jones,
Come
it
on.
Looks like you had court yesterday on a charge of possession of cannabis, possession of paraphernalia, and possession of methamphetamine. It looks like something had happened at the jail. There was a new charge of battery on a law
Smoke weed
enforcement
every
officer.
day.
Apparently, they weren't able to handle that fourth charge. They brought you back on all 4 today. Sir, do you want me to appoint the public defender on all 4 of these charges? I'll go ahead and appoint the public defender on all 4 charges. I've reviewed 2 separate affidavits finding probable cause for all 4 charges. I can see that you already have an open case. It's not a parkable offense, but you have an open case apparently when these 4 new charges were allegedly occurred. So I think enhanced bonds are appropriate. I'm going to set your bond on possession of cannabis at $2,500. It'll be $2,500 on the paraphernalia, $7,500 on the meth, and $7,500 on the battery on a law enforcement officer.
Smoke weed
Add it
every
all up,
day.
it's $20,000. Have a nice day, sir.
Hey, the lady from yesterday, she hasn't came on yet. As a matter of fact, she's
All
right.
Mr. Tribble, go right ahead.
Your Honor, first up, Giuliano Castagni.
I think that Mr. Castagne is our only Spanish of the day. Mr. Hernandez, I think he's
Woohoo! That's what I'm
Right
talking
here, Your
about.
Honor.
great. Mr. Castagne, you are charged with failing to appear for court on multiple hearings. Looks like the charge was a solicitation.
Solicitation. Oh, he's a John.
Usted está acusado, señor, de una incomparecencia en la corte, incomparecencia para múltiples audiencias. Parece que el cargo era solicitar.
Hey, what up, Sean? How's it going? Yeah, I do have 2 pages,
One
Ash.
second, sir. I'm just grabbing your paperwork, so I have it in front of me.
Actually, I got
Muy
3.
bien, espera un momento, señor. Estoy buscando sus documentos para tenerlos enfrente.
Mr. Tribble, are you representing Mr. Castagne on this felony charge?
Yes, Your Honor.
Señor Trevor, ¿está usted representando al señor Castaña aquí en este cargo de un delito grave? Sí, su señoría.
And I apologize, it's a misdemeanor. It's a misdemeanor
Y
charge.
pido disculpas, realmente es un delito
Minor
menor.
involved? Oh, hey, you
Sir,
guys
I
wood chipper
looked
time.
over a capias that was issued by Judge Williamson, and I find probable cause.
Señores, he revisado una orden de arresto que fue dictada por la jueza Williamson y encuentro que hay motivo fundado.
Judge Williamson wanted you held no bond with a 5-day hearing.
La jueza Williamson deseaba que usted se le retuviera en la cárcel sin fianza con una audiencia dentro de 5 días.
She's no longer in that position, so we'll send you to see Judge Gibson on April the 4th. Or
Hey, Nicole, thank you.
April the 8th. April the 8th.
Ella no se encuentra ya en ese puesto ya más, por lo tanto nosotros lo enviaremos a usted a ver a la jueza Gibson el 8 de abril.
Have a nice day, sir.
Your Honor, just so the court is aware, he was in custody in Seminole County during that initial failure to appear.
Yeah, that might be something to bring up with Judge Gibson.
Your Honor, up next, I have David Perez Valdez.
1 second. Mr. Hernandez, I don't know of any others. Would you like to make an announcement?
I will, Your Honor. Buenas tardes. ¿Alguien más va a necesitar español para el servicio de español? Por favor, levante la mano para saberlo.
Raise your hand up. Please stand up.
Spanish. Mr. Hernandez, have a great long weekend.
They might have picked
Judge, we
everybody
have
else
one
up
more.
already.
Judge, we have one more.
What?
We have one more.
We have one more. Of course we do.
Yeah,
Tell us who
two
this
more.
one more is.
Hey, thank you, Hector. Thank you for providing the links. Highly
Yeah.
appreciate you.
Pase adelante, señor. Venga.
Come on down.
Ven, por favor, pase al podio.
Ven aquí, that was it. Ven aquí. Hey, Passion, thank you for that daily heart. Highly appreciate it. Don't forget, tap that screen. It's free tapping that screen.
Sir, what is your name?
Señor, ¿cómo
Howard.
se llama?
Howard Crespo.
Elvis Crespo.
Crespo.
Is
Yeah.
that the
Martinez.
singer?
Mr. Crespo,
What up,
make
Frank?
sure you wait till she translates in Spanish before you answer my English question, please.
Señor Crespo, por favor, espere hasta que la intérprete haya interpretado la pregunta antes de contestar, por favor.
Sir, you're here because you failed to appear for court on 4 charges.
Señor, usted se encuentra aquí porque usted incompareció en la corte donde tenía que presentarse por 4 cargos contra usted.
Those 4 charges are possession of firearm by convicted felon,
Ooh.
Esos 4 cargos son los siguientes. Uno es de posesión de un arma de fuego por una persona que ha sido condenada anteriormente,
aggravated assault,
amenaza con agravantes,
discharging a firearm in public,
Oh, no.
disparar un arma de fuego en un lugar público.
He's definitely going to
and
prison.
lastly, tampering or fabricating with evidence.
Y por último, un cargo de manipulación o fabricar pruebas o evidencias.
Hey, thank you for that daily
Mr.
heart.
Crespo, do you want me to appoint the public defender or do you already think you have an attorney?
Or do you want to kiss
Señor
your
Crespo, ¿usted quiere que yo
ASS
le asigne
goodbye?
un abogado de oficio o usted cree ya que tiene un abogado?
Yo tengo un abogado ya, privado.
I already have a lawyer.
I thought you might. You'll not show that? Mr. Crespo.
Mr.
He failed to appear at
Crespo.
mandatory docketing, so I would think that on a felony, mostly by that point, he has an attorney.
Yo pensé que él tenía ya un abogado.
Hey, and those Florida prisons are, there's something ugly from what I hear.
So right now, he has no attorney.
That's correct, Your Honor.
Sir, it
Una
doesn't look like
moción.
you,
I'm sorry, Your Honor.
that's okay.
Hubo una moción para retirarse de manera que no tiene abogado.
Hey, what up, Lisa?
Sir, you had one. but that
Hasta la
attorney
vista,
withdrew from
baby.
your case.
Sí, usted tenía un abogado, pero ese abogado se retiró de su caso.
Do you want me to appoint the public defender or are you going to try to hire another private lawyer?
Hey, what's up, Jessica?
Señor, ¿quiere usted que yo le asigne un abogado público o va usted a tratar de contratar otro abogado privado?
Haciéndome uno público.
Public defender, please.
I'll appoint that office to represent you.
What up, Ginger
Voy
Snap?
entonces a nombrar esa oficina para que le represente a usted.
I'm finding probable cause based upon the capias that's been issued.
encuentro que hay motivo fundado basándome en la orden de arresto que fue dictada.
That circuit judge wants you held no bond,
Ese juez de circuito quiere que se le retenga a usted en la cárcel sin fianza.
we'll send you to see that circuit judge for your 5-day hearing on April the 8th at 9:30.
Y vamos entonces a programar para que usted vuelva a ver a ese juez de circuito dentro de 5 días en una audiencia que se llevará a cabo el 8 de abril a las 9:30.
Have a great day, sir.
Tenga buen día, señor.
Igual.
The same.
All right. Any other Spanish speakers?
¿Alguien más que hable español, por favor?
So, Mr. Hernandez, let's do it this way.
Francisco Caballero.
Make your announcement one more time, and I want people to hold their hand high. And if they ain't hold their hand up high, they ain't gonna get an interpreter.
Muy bien, voy a repetir mi aviso. Por favor, alguien que hable español, levante la mano y
EA
manténgala
Sports.
levantada
It's in the
para
game.
saber exactamente cuántas personas necesitan. Por favor.
Well, I should restate that. They won't get one today. They'll get one tomorrow, after, because you're gonna be released next. And they'll get the interpreter tomorrow. All right.
Muy bien. Entonces ya tenemos el señor. Ok.
What? Yeah. Okay.
Mr. Hernandez, before you leave, apparently we have someone that needs a Creole interpreter. I'm not sure they're gonna get their interpreter today either.
Creole.
So you can check with your office to see if one's available.
I will call them and ask them. Ok.
All right, thank you so much. Sir, what's your name?
Señor, ¿cómo se llama usted? Su nombre, por favor.
Francisco Caballero.
Francisco Caballero.
Mr. Caballero, you're charged with driving a motor vehicle with an expired driver's license more than 6 months.
Señor Caballero, a usted se le acusa de manejar un vehículo con una licencia de conducir vencida por más de 6 meses.
You want me to appoint a public defender to represent you?
¿Usted quiere que yo le nombre un abogado de oficio que le represente?
¿Sí?
What up,
Yes.
Kevin?
I'll appoint that office to represent you.
Voy a asignar esa oficina para que le represente a usted.
I've looked over your paperwork. I find probable cause. Your bond is $250.
He revisado su documentación y encuentro motivo fundado para el cargo. Su fianza es de $250.
Now, I am aware that you currently have an ICE hold.
Pero
Oh, that was
estoy al
done.
tanto de que usted en este momento tiene una orden de retención de ICE.
So I'm going to ask the clerks to my right to prepare a detainer for my signature.
Entonces voy a
somebody say,
solicitar
"Aw"?
a la escribana a mi derecha para que prepare una orden de retención para que yo la firme.
Have a great day, sir.
Tenga buen día, señor.
Senor Caballero got iced. You guys
All
ain't right.
Mr. Hernandez, I think that's all the hands other than that now one Creole interpreter that you're going to check for me. Have a great day.
I will check for you. Yes,
Thank
yes,
you
the
so
same.
much.
The same for you. Nice day.
Yeah, you too. Mr. Tribble, where do we leave off?
David Perez Valdez.
David Perez Valdez. Come on down to The Price is Wrong.
All right. Good afternoon, sir. You are charged with 100 counts
100?
of second-degree felonies. Mr. Tribble, are you representing Mr. Perez Valdez on these matters?
Yes, Your Honor.
Sir, I've looked over a warrant that's in front of me signed by Judge Franklin. She signed it yesterday. She's already found probable cause, but I've gone behind her and I find probable cause as well. Mr. Tribble, would you like to be heard as it relates to bonds on these 100 counts?
100?
A reasonable bond amount, Your Honor, since there is such a massive amount of charges.
Yeah. Would the state like to be heard on bond on these 100 counts?
Your
100.
requested the standard second-degree felony bonds according to the schedule. Additionally, Your Honor, state would request for pretrial release conditions
100 counts of what,
and
right?
25.
I don't know. Whatever 100 of it is,
All right.
it's bad.
Mr. Perez Valdez, I'm going to set your bond. Let me just tell you this ahead of time. Most folks, I think, would say that the typical bond for an F2 is $15,000, although administrative order doesn't get a strict amount for that, unlike an F3. But typically you'll see that I'll give 15,000 for your garden variety F2. In your case, because of the sheer number of counts, I am going to reduce that a little by a third. I'm going to set your bond on each one of these 100 counts at $10,000.
What? That's like a gazillion dollars.
Doing the quick math, I think that comes up to what, $1 million? Yeah, that'll be $1 million. Anything I do here certainly is subject to modification by the judge that's presiding over your case, but just so we're aware, I haven't gone less than what I typically would do, and I think most would typically agree is a standard bond for an F2. If you're able
What
to
up,
post
Grandma?
that bond or those bonds, you're going to be on pretrial release. So you'll have to immediately check in with pretrial release services here in Bartow, sign up in person, calling them. Let's see, calling them on Mondays, Wednesdays, and Fridays.
Hey, what's a F2?
You have all the standard conditions. Can you pull up that pretrial form so I can look at it?
Is that a felony too?
You have all the standard conditions that everyone has, plus the following special conditions that
Felony
Judge
second
Franklin,
degree?
who signed the warrant, wants you to have. Condition 17 says you can't have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, as well as their homes, vehicles, place of employment, or any school they attend.
Hey, this is
In
going to
addition
be.
that, I'm going to require that you have special condition 22
What up, Katie?
and 22A.
What's
as well
22 and
as
22A?
Special condition 25, that'll be explained to you later.
What's
Mr. Tribble, anything else on Mr. Perez's case?
Nothing additional.
Step to your left, please.
I'm gonna go out on a limb and I'm gonna say it's probably child related or some type of SO type of activities, if you will.
What's 20?
But that was definitely done. Whatever he did,
I didn't recall.
his last day of freedom was the day he got arrested.
Judge Franklin checked it. Go ahead and check it too. Yeah, absolutely. Mr. Tribble, who would you like to call up next?
Finally, Your Honor, Judah Yadhe Wahe.
There you go.
No internet. Yup.
Sir, you're
Alright.
charged with domestic violence battery by strangulation.
Oh damn.
Do you want me to, well, Mr. Tribble, you're representing the gentleman on this case?
Awa.
All right. Gentleman's approaching the podium now. Sir, I've looked over your affidavit back in my office. I find probable cause. I'm going to set your bond at $5,000. Make that bond a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Thursdays. You have all the standard conditions plus special conditions 16 and 17, which says, while on pretrial, you can't use, possess, or carry any firearms, guns, weapons, ammunition, knives. You're not allowed to have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, as well as her home, her vehicles, where she works, or where she goes to school. Mr. Tribble, anything else on this gentleman's case?
No, Your Honor, that's all I have.
All right. Have a great day, sir.
Imagine being so
I see we
upset
have one attorney there.
and mad that you
Hold on,
strangle
I have a
somebody?
debate Here, I want to get him.
like
done
just
real quick.
wrapping your hands around their neck.
No problem, Judge. Thank you.
That's wild.
Deputy Letchworth, remind me the
Thank you,
gentleman's name.
Cindy.
Mr. Snell.
Mr. Snell.
No, I was being a challenge to make on that report already.
Sure. Give me 1 second.
Hey, and just to give you guys a heads up, I'm gonna be on for about an
Mr.
hour
Snell,
more.
You are here. Now, it's Austin Snell.
Yes, sir.
Mr. Snell, you're here on warrantless VOPs. There's 4 of them. You're on probation for trespass, resisting a Leo, resisting an officer without violence, and threats of death or serious bodily injury to another. Do you want me to appoint the public defender to represent you?
Yes, sir. I was under the impression that John LaGore was my attorney, but I haven't been able to contact him due to lockdown inside the jail.
Okay, I mean, if you heard my speech at the beginning, you were sitting over here beside me. If you wanted to postpone this to try to get Mr. LaGore here, you certainly are able to do that.
I know we were here today.
Oh, it was yesterday? I
Yes,
didn't know he was
my
here.
understanding is
I
Mr.
wasn't here
LaGore.
yesterday.
Yes, Mr. LaGore has not yet entered an appearance on behalf of this gentleman, so.
All right. So, sir, if it sounds like you were here yesterday and they brought you back today to try to get Mr. LaGore here,
Yes, sir.
again, I've been here a lot lately, but I wasn't here yesterday, so I didn't quite appreciate that. I have Mr. Snell's affidavit in front of me. Ms. Goins, go right ahead with any probable cause challenge.
Yes, I'm going to brush Your Honor.
Sure.
I'm handing court a copy of a case I'll be referring to, State versus Robinson, 773 Southern 2nd, 566, which is still good law. The reason that's relevant to this particular probable cause challenge is because, as I have read over the affidavit, the probation, and this was apparently Mr. Snell had come in to do, I guess, to be drug tested. He tested negative for marijuana. And this is related to
smoke weed every day.
So he tested negative for marijuana, but apparently, according to the probation officer, Mr. Snell allegedly admitted to using THC around sometime last week. This is the only allegation in the VOP arrest. And is our position that even in VOP, I guess likening it to the corpus delicti, that when you are saying that there is a violation of the law that has been acquired by a probationer, that you still have to have other information which would require proof of the substance and what crime was committed. Saying to a probation officer,
Brittany, nah, it's not.
I used marijuana last week, or I used it yesterday,
Smoke
is
weed
not
every day.
sufficient to support probable cause for a violation of probation in this case. And because of that, according to the State versus the second DCA and State versus Robinson, which is a 2000 case, but still good law, it says generally a violation of probation condition requiring the probationer to live and remain at liberty without violating the law requires proof of a date, a location, an actual possession or actual use of an illegal drug rather than just an admission to being a drug user. So this is an unusual situation because it is the only allegation in the probation affidavit, but it's all that's holding him.
What's unusual is that in
And
Florida,
the state could not
that ganja
prove
is still
this in
illegal.
court.
That's
And
an
even
outrage.
coming in here, a probable cause standard, they have no proof that any crime was committed.
Well, she's definitely worth her
And
money in
I
gold.
know there's probably a condition saying you're not supposed to use drugs or alcohol. Again, in order to prove that, you have to have proof, not just an oral statement. And I would liken that to the corpus delicti that we use in establishing whether the state has sufficient evidence for their case.
What up, Kester?
Trial.
Man, I mean, I would have been signed up for a medical card.
Your Honor, at this point in time, state is arguing
Sign
that
me
there is
up.
enough to find probable cause for the violation in this case, specifically pointing to number 7 on the order of probation. Defendant is not to use intoxicants or possess any drugs or narcotics unless prescribed by a physician. Special condition number 2 is do not consume, possess, associate with, or visit people or places where alcohol or drugs are used.
I would have kept my mouth shut.
Based
I wouldn't
upon
have
this
made it
case,
to
Your Honor,
anything.
state would argue that this case law is not applicable. Specifically, the case referenced by the defense is in reference to a probation revocation proceeding. That's the DOP hearing itself. That doesn't apply to what we're here today for is first appearance. Your Honor, regardless of how strong or weak the evidence is, as I've heard you say many times, what we're here for first appearance for, probable cause, the bar is fairly low. Based on the evidence that we have, Your Honor, state will argue that there is enough to find probable cause in this case. Request this case be sent over to the Violation Probation Division at this point.
Does anyone argue with the notion that we all know VOP hearings, state can call him as a witness, state can introduce hearsay. But anyone disagree with the notion that you cannot base a VOP solely on hearsay? 100% hearsay.
That is correct.
Okay. So I'm struggling to see how this could ever.
Get through a.
Your Honor, throw it out. Let him go.
Again, it is a low bar. It's a low bar. But if the entirety of the motion, of the VOP is he admitted to using something, and we all agree that hearsay is admissible, he can even be a witness, but you cannot base it solely on hearsay. How else? What else would there be if he's already tested negative?
There is nothing.
Yeah.
Okay, that's the whole point. And I guess and again, that's why I liken it to the corpus delicti. I mean, there is nothing to support the allegation. Therefore, as the state would suggest, well, if there's some, we're just going to go ahead and arrest everybody who makes some kind of a statement to the probation officer, and I will also have to inject this. Most of the time, probation officers don't believe defendants. So you also have that question, I guess, if it's something favorable to the defendant, they're not going to believe it. But if it's something that they say is adverse, but there is no evidence to support probable cause that he has violated his probation. Likewise, once you get to court, there won't be any evidence for a court to base a violation on, and certainly no evidence to revoke a probation.
Just a little side note, as a county judge, do a lot of DUIs. In my experience as a lawyer, where DUIs rears its head a lot is in DUI. Where corpus delicti pops up a lot is DUI. Judge Altenburn, who's, I guess, one of the judges on this particular case you gave me, he has a great case where he basically says this whole corpus delicti mumbo jumbo, I'm paraphrasing, is rooted in the ancient England. Corpus means the corpse, the body of a crime. Basically, the person in the town that's known to be a little not all there could confess to killing somebody. Well, the corpus delicti says, well, you can't really prosecute him for murder, convict him of murder without a body. That's where the corpse comes from. So it's rooted in Robin Hood days. And Judge Altenburn says, that corpus delicti might have seen its day. It really doesn't. In this modern time, he's not 100%. He goes on a little bit of a concurrence in saying, it's good law, but man, we really ought to look at it to see how much longer we're going to let corpus delicti hang around. Now, I know he's now retired, but there's a great case that he goes into.
Yes.
That all being said, I just don't see how in the world I should hold this gentleman on this case, where I know the only evidence, the case law says that's the only evidence they have, and that's not enough. I just don't know how I would be doing the right thing by doing that. I don't get to dismiss the VOP. I'm not saying I would, but my intention would be to let you out of jail.
Let him out.
The VOP. And that judge, when you have your VOP, might say, well, I think I disagree with Judge Stamey. I think there's enough here, and there might be some case law or something new that's been added. But right now, I just don't see how there's probable cause to hold him. So I'm going to ROR you on this, sir. Again, you have a VOP hearing. You're not out of the woods yet, but you're going to be on the street while you wait for your hearing, which is going to be on April the 28th.
Thank you, sir.
Have a great day, sir.
Woo! That's what I'm talking about. Hey, he definitely had a good lawyer on his hand.
All right.
Whatever he paid for her.
Go right ahead.
Good afternoon, Judge. How are you? Richard Moncada on behalf of Johnny Luster.
Johnny Luster. See, Johnny Luster, come on down.
So, Judge, a couple issues here. Mr. Luster's case keeps getting reset week after week. He's been in custody for weeks at this point. I've tried to contact Lee County, the assigned prosecutor. I've tried to reach out to corrections offices on both parts, Judge. He's just sitting right now in Polk County. The nature of the violations, Judge, bottle of alcohol, ammunition, I understand is a violation of probation. However, we have very good arguments towards these, Judge. One being the ammunition is he had recently bought a cop car.
A cop car?
That ammunition, Judge, is there's an explanation for everything, Judge.
Mm-hmm.
Point being, he's being held. Lee County is, based on my attempts to have him transported, they're not responding. The state prosecutor in Lee County are not responding, Judge. I would really be requesting Mr. Luster to be released today, or at least establish some sort of deadline that Lee County can come in and grab him, Your Honor.
When did Mr. Luster get taken into custody? Looks like it might be around March the 18th. And how many times has he been back to first appearance to see a judge about his Lee County hold?
This is the third.
What up, Dayton?
So I guess he would have they're alleging this happened 3/18. He probably came to court the next day. Then he came to court probably a week later. And now he's back for the third time. Mr. Moncada, I don't claim to be an expert in this, but what I've learned from this position is, Lee County, these various police departments, I should say, various sheriff's departments go back and forth all the time, bringing people to and from various jails. They do it quickly when a judge in their county, like Lee County, a circuit judge signed a warrant, they'll be over here, yesterday. But if it's a warrantless VOP, they don't seem to be in all that much of a hurry to get over here, probably because they're slow playing it, waiting for a warrant to be signed by a judge once the affidavit is made. Once the basis for the warrantless VOP gets put in the form of an affidavit and put in front of a judge down there, once it's signed, they come pretty darn quick. That's not not an excuse, but it's just my observations. So he's been here over 2 weeks. Polk County taxpayers are paying for a Lee County case. We don't mind staying a little bit, but at some point, Lee County needs to be paying for their people in their county. So what says the state as to the defense's request as far as releasing him? What would the state have me do?
Your Honor, I think we give Lee County just a couple more days.
A couple more days?
At that point, if they haven't responded or if there hasn't been a link that's come through and haven't picked them up, I think at this point, Your Honor, there's not much more that we can do at this point.
They don't want him.
Mr. Moncada, I'll give you the last word. Anything else you want to add?
No, nothing further, Judge.
Okay, this is what I'll do. He's been there 2+ weeks. 3 weeks is plenty. I'm going to go ahead and put on here that if this gentleman, Mr. Luster, has not been picked up from the Polk County Jail by Thursday, April the 9th, 1 week from today, at close of business, 5 p.m., at that time, if he's not been picked up, he should be released from the Polk County Jail. Now, he still may have a VOP down in like the last gentleman. I'm not saying that your VOP goes away. I'm just saying you won't be in the Polk County Jail while you're waiting to go see your judge down in Lee County. But if they come to get you between now and next Thursday at 5 p.m., then you'll be on your way down south. If not, Polk's going to release you, but you're going to have potentially still have that VOP down south. Anything else, sir?
Nothing further, Judge. Thank you so much for your time.
You bet. Have a great day. All right. Any other special requests? Any other private attorneys waiting?
What up, Well?
If not, let's get moving. Folks, we're going to do the gentlemen at the south first, then to do the ladies there at Central and finish up with the men in the back.
Yeah, we want to see the
Get
ladies.
a good steady pace going to get you guys off those hard benches as quick as I can. That being said, there's only 4 things I do today. You heard what I said during my speech. I tell you what you've been arrested for just in case you don't already know. Then I'm going to talk to you about a lawyer because everyone's entitled to a lawyer. If you want the public defender, I'll provisionally appoint them. If you want to hire your own attorney, we'll make that notation and move on. The third thing is I determine a probable cause. As I've said, I've already read everybody's affidavit back in my office. I have a good idea what I believe is there or not there. And finally, I'm going to set a reasonable bond, but I'll listen to both sides if they have any arguments to be made. That being said, please don't come up here and start talking about the facts of your case. So often I see someone who says, "Hey, Judge, can I ask a question?" And they proceed to tell me all about the case. And I'm thinking, man, don't they know that little blue light's on right there that tells the world that everything's being recorded? And wouldn't that be ironic if the very first piece of evidence the state attorney uses against you at your trial is you telling me things that you really shouldn't be talking about at first appearance? So please keep that in mind as you're at the podium. You shouldn't be talking about the case. All right, let's start with the South County. We're going to do Raymond Baden first. Troy Raymond Baden. Mr. Baden, you were charged with trespass in an area maintained or secured by law enforcement. It's a felony. Do you want the public defender?
No, sir.
If you change your mind, you can always ask later. Find probable cause, setting your bond at $5,000.
Does he have glasses on?
That, please. Heath Barton.
No, he don't have glasses, but something about his look is definitely off.
Mr. Barton, you're here on 3 warrantless VOPs. What put you on probation was burglary, grand theft, and burglary. Do you want the public defender?
Yes, sir.
There another county? I'm sorry, I did. Okay, so sir.
Hey, what up,
you have 2
Alexander?
Osceolas. I can't appoint the public defender on Osceola, but you do have 1 Berg dwelling on a 15 CF case number that you can get the public defender if you want.
Yes, sir.
Okay, I'll appoint the public, hold tight. I'll appoint the public defender on the local Berg dwelling. You don't get the public defender on the Osceola cases, at least here. You can ask for the public defender when you get back to Kissimmee, or you can always hire an attorney at any time. I've looked over the paperwork. I find probable cause. I'm going to hold you no bond on each of these 3 charges. You had something you wanted to ask, sir?
Yes, this was supposed to be, yes, I came to first appearance yesterday and seen the other judge. I was supposed to be brought back today because the other 3, I think it was count 1, 2, and 3. It was she's seeing that she didn't see no type of probable cause, and it was for Osceola, where I got sentenced to 5 years in prison, ran concurrent with this sentence over here.
Not this guy again.
Followed by 2 years probation. That's where the mix-up was. I believe in my just knowing what happened, and the affidavits and the officer that arrested me, he put that in there like that. So I don't have probation in Osceola. There is no VOPs. There is no probation. So the judge wanted that, gave Osceola 24 hours to get it cleared up, or she was going to throw him out. I believe that's what was said yesterday.
I remember any of that from yesterday.
Mr. McKinney, are you there from DOC by any chance, sir? Or someone, a representative from DOC?
Yes, Your Honor. What can I do for you?
Yeah, this gentleman's of the belief that he is not on probation out of Osceola County case.
Does anybody remember
case,
the judge saying that?
CF 3588. It doesn't sound like he's got a gripe with that. He just doesn't believe he's on probation for a burglary and a grand theft out of Osceola County. Can you confirm or deny that?
Sure. Give me just a minute, Honor. I'll get back with you.
Sure. Mr. Bart, why don't you have a seat real close there? We'll call you back. Mr. McKinney, he's a probation officer with DOC. We'll see what he says. All right. Next up, we have Hamilton Bradley. Mr. Bradley, you're what we call Hamilton Bradley. Sir, you're what we call a fugitive from justice from Harrison County, Texas. It means basically you got a warrant from another state.
Yes,
Do you want me to appoint the public defender to represent you during that extradition process?
Yes, sir.
I'll appoint them. I've looked over the paperwork, finding probable cause, going to hold you no bond, and you get to go see a circuit judge quickly on your extradition back to Texas. Have a great day, sir. That'll be 4/7. We're up to Jamar Clark.
Jamar Clark, come on.
Mr. Clark, you're here on a case that's out of Pinellas County for failing to appear for court on a driving while license suspended.
What up, Lori?
I cannot appoint the public defender on a Pinellas case while you're in Polk County, but you can always ask when you get back over to Clearwater, or you can always hire a lawyer between now and then. I find probable cause. The judge over there has set your bond at $2,013, so you are bondable. If for some reason they don't come to get you quickly, or you don't bond out, we'll bring you back a week from today to talk it over with the judge. Have a great day, sir.
What about I had a VOP from Pasco.
I don't know anything about that.
All right.
Have a great day, sir.
Yeah.
Gerald Deal.
Gerald Deal, come on
Mr.
down.
Deal, you have 3 new charges and 3 warrantless VOPs. The new charges are possession of cannabis, possession of drug paraphernalia, and violation of injunction for protection against domestic violence.
Agua.
VOPs are based upon dealing in stolen property, false ID, DeLeo, 2 counts. Do you want me to appoint the public defender on all 6 of these matters?
Yes, sir, definitely, sir.
All right, I'll go ahead and do that. I had a question real quick for the
Yes, sir.
attorneys.
I live in that. Go ahead, sir.
I know, real quick. I think I might have already answered it. And right before I left my office, after having read your original affidavit, a new affidavit was provided, and I just grabbed it and came down here. The question I had for the attorneys was going to be, where does this possession of drug paraphernalia come from? It's not been charged. Well,
As well,
they must have seen the same thing I did, because the state has provided an amended affidavit, I should say, that does go back and it charges the paraphernalia. Just so you know, when I read the body of the affidavit does talk about plastic baggies, which of course is paraphernalia. They just didn't charge you on the original one. Must be a typo.
sir, it was in my dresser drawer and my mother had called the,
Shut your mouth.
Blue lights on. The injunction has been.
I know you want to talk about it, but you really shouldn't, okay? You
May
shouldn't
I,
talk
may I
about
please talk to the public defender then, and thank you.
well, you can't talk to her during the hearing. But
Yes, sir,
certainly
whenever I get the chance.
send someone out to you.
Thank you.
You bet. All right, so let's get back. Now that I've seen the amended affidavit that does charge him with the paraphernalia, I do find probable cause for all 6 charges. I'm going to set his bond on the paraphernalia at $2,500, on the cannabis $2,500, and on the domestic violence injunction, I'll set it at $2,000.
Smoke
Make
weed
those
every
bonds
day.
conditions of pretrial release. Sir, if you're able to post those bonds on the new charges, you'll have to check in with pretrial, sign up in person, calling them on Thursdays. You have all the standard conditions, plus the following special conditions. Can't have weapons or firearms in your possession. You can't have intentional contact with the victim, and you must abide by any injunction that's currently in effect. Now, on the VOP, sir, I am going to hold you no bond. Have a great day.
Imagine living with your mom at that
The
age.
injunction was removed. That's my mother, and I've lived there on probation for the last year and a half. And that little joint or something was in
What
my
up, Tommy?
dresser drawer. I don't know what else to say. I don't mind saying it. I'm not supposed to say things during blue lights, but my
Mr.
mother
Diaz.
called for a reason, but not for the injunction. I just need the paperwork to be straightened out on that because she.
Excuse me, Mr. Deal. My name is Deborah Goins.
Too late.
I'm an attorney with the Public Defender's Office. You are not benefiting yourself at all at this point.
Thank you, Ms. Goins.
Even if the judge, I guess, even if he wanted to, but he can't make decisions on your
Yes, ma'am.
case.
Hey, what up,
There's
Arturo?
sufficient evidence. You need to stop talking. And
Ms.
you
Goins,
will
thank
be visited, by somebody from the Public Defender's Office.
Thank
All
you.
right? You need to stop talking in court.
Yes,
It's
ma'am.
not
Thank you.
helpful.
I don't think he
Okay.
knows how to do that.
Thank you.
All right.
Have a nice day, sir. Next up is Jonathan Harden.
Up next on The Price is Wrong.
House. He was not brought back yet.
What up, Droopy?
What do they say about Harden?
He hasn't made it back from the courthouse yet.
Hey, what up, Trish?
They did not
Okay.
bring him to us.
Before we finish up with South County, if he's not there, let me know. We can always bring him back tomorrow. Okay, we'll circle back before we finish with you guys. Next up, we have Aaron Nitty.
Aaron Nitty, come on down.
Approaching.
Mr. Nitty, you're charged with a warrant out of Brevard County for failing to appear for court on a charge of trespass.
What up, Smoggy?
I don't get to point to the public defender, but you can hire a lawyer if you choose. Finding probable cause, your bond is $500. Have a great day, sir.
You're talking about Aaron Nitty?
Yeah.
Yeah, and the horse for Brevard.
I want that lady to come up. I wonder if she's gonna be as chatty as yesterday.
Yeah, it's $500 out of Brevard County. So I did appoint the public defender, found probable cause, it's $500.
Well, he's a bring back from the 27th of March.
Oh, so this
I
is
won't be doing parole hearings today.
This is a, okay, well,
He's an
this is only 1 week.
Okay.
By that, I mean, Mr. Go back to Nitty real quick, please, Devin.
Yeah, just when do we bring him back? That's what I was saying.
Bring Nitty back up, please.
Hey, I'm not doing too bad today.
Which one you're?
Mr. Cox, hold tight 1 second. I'm right in the middle of something. Can you pull Nitty back up? Yeah, the guy I just had, the very last one.
Hey, Ryan, thank you for that. Highly appreciate that. It's super cold in there.
So in
I could
Mr.
imagine.
Nitty's case, to your point, Ms. Goins, being that I wasn't, it's always the frustrating part about this job. They'll tell us who the bringbacks are. Whether they were brought back yet for yesterday because they're in the hospital, they're in transit, I don't know. They just call them bringbacks. They lump them all into the category.
Hey, Colton,
Whereas,
thank
as
you.
Said he was here a week ago, and I think I was the judge that day. The point is that I'm sure if I was, I told him that we'd bring him back today so he could talk it over with the judge. I'm not prepared. It's a Brevard County. I'm not prepared to cut him loose right now on a capias. But I will bring him back next week on the 9th, but certainly by the 9th, if he's not picked up, he probably could talk me into a deadline.
Talk you into a deadline.
Mr. Brevard.
Hey, what up,
If
Siwa?
Mr. Nitty can put up the $500 bond, then he is free to do that.
Sure.
And he would need to return to Brevard County to let them know that he is, he's available.
Yeah, absolutely. The Polk, he bonds out here. Polk will eventually tell the clerk in Brevard that he's bonded out and they'll send him a notice, but yeah, nothing prevents him from bonding out here and hustling over to the clerk's office in Brevard and saying, when's my court date?
Okay.
Have a great day, sir. We'll bring you back a week from today if you're still here and haven't bonded out and they haven't picked you up.
Hey, Shannon, good eye. Yeah.
Pysock,
Jay Paisa. What the what?
Approaching.
Mr. Pysock, you're charged with trespass. Do you want the public defender?
Yes.
I'll point him. Finding probable cause, your bond's $1,000. Have a great day.
Huh. Look at that
That brings
whippersnapper.
us to Stephen Warner.
What up, Renee?
Mr. Warner, you're here for 4 charges. Do you want the public defender?
Yes.
I'll appoint the public defender. Sir, I find probable cause for the 4 charges. They are, and here's their bonds. Possession of drug paraphernalia, $1,000 bond. Possession of cocaine, $5,000 bond. Possession of cannabis resin, $5,000. And possession of MDMA.
Damn.
Some call it ecstasy, is $5,000. Have a great day, sir.
Damn, he had that Molly on there. He was a party. He was definitely a good time.
Yep, I'm going to prison.
Yeah, he is going to prison. Hey, hello, Governor.
Do we have
Sorry,
Mr.
Your Honor, he was not brought back from court either, him and Hardin. We just called and confirmed with.
Yeehaw! Hey, thank
They
you,
haven't been
Colton.
brought back yet.
Appreciate that.
All right, Ms. Goins, I think we're done other than,
You
here for
skipped
Mr.
over.
He did say, "I'm going to
Batallas
prison."
Eduardo, he was skipped.
what was his last name?
Batallas, Batallas.
But
Caesar.
Tullis?
Right, I did. I apologize. Caesar Eduardo Batallas. Sir, you're here on a warrant out of Osceola County. It was for failing to appear for a status hearing on a trespass charge. Sir, real quick, would you mind, raise your right hand for me if you don't mind. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yeah, I'm gonna tell the truth.
Okay, you put your hand down. If you don't mind, tell me your name.
Caesar Batallas?
Is your date of birth April 24 of 1992?
Yes.
Somebody had you down as being 1994 birthday, but you're 1992?
Yeah.
Okay, just wanted to confirm that you are April 24 of 92. Sir, I find probable cause. The judge over there in Osceola wants you held no bond. We'll notify them that you're available for pickup. Tell them to come get you. If for some reason you're still in our jail, we'll bring you back a week from today to discuss it like I've been doing with some folks already today. Scott,
I think he's got locals, so he's gotta resolve his locals before he comes bond.
so why is he even here? Did he not come through with the locals?
Maybe bonded. We'll double check your answer.
Yeah. So hold tight, sir.
All right
Man, oh
then.
man, this area of bringbacks is one area I wish some smart people could put their heads together and come up with a better system of differentiate. Maybe it requires a set aside docket, maybe later in the docket where they're all in the same posture. Something where they're not just lumped in and they're just labeled bringbacks. Maybe some guidance as far as.
Just as an aside, Your Honor, I'm provided with the first appearance order in my packet. So I can see when they were here the last time, and I can track it all the way back. One of the cases was like a month and a half.
Wow.
So that's how I know, but I didn't realize the court doesn't have that in front of you unless you look back.
Yeah, Miss Leatherwood tells me who the bringbacks are, but again.
What up,
bringbacks
Emily?
Could be yesterday, they were in the hospital.
Okay.
Yesterday,
He had court this morning, an arraignment, and they set up for competency on it.
so he does have local charges. And was he ROR'd or was he still on bond on this?
He had a bond at first appearance at 250, and then he RR today.
So has he the triggering is, has he bonded out?
Right.
If he's in our jail on a
No,
bond,
sir. No, sir. Not yet. Bond.
so he's still in the jail on
So he
bond.
still has locals,
So
correct?
why is he even here?
That's a good question.
All right, Mr. Vitalis, not to bore you, but there's a logical way these things are handled. If you got a warrant from, say, like you, Osceola County, but we arrested you on some Polk County charges and you're in the Polk County jail, well, Polk's not gonna say, all right, come get him, he's yours, because we're not done with you yet, because you have Polk County charges. But if a person in that scenario bonds out, or the state drops it after you were being held originally, or you enter a plea, well, at that point, now Polk County case isn't holding you anymore. They'll bring you to first appearance, so I can tell you, all right, now you're free to go back to Osceola because we're done with you, and we'll notify them to come get you. Well, for some reason, you were brought to see me today, even though we're not done with you yet, so to speak, using my terms. It looks like you're still in custody on a Polk County case, on a Polk County bond. So candidly, we're not going to let you go until you either bond out or you resolve the case or get ROR or what have you. So I will tell you that I would find probable cause to hold you because of the FTA out of Osceola County. That judge over there wants you held no bond. So we'll hold you no bond. And once all your local charges are done, they'll bring you back. So a judge like me can say, all right, we're going to call Osceola to come get you. Okay. Have a great day, sir.
No secret.
Your Honor, Deborah Goins on behalf of Mr. Vitalis. I just wanted to clarify what the clerk was saying. Is this potentially going to be a misdemeanor Division 8 case?
There's two case numbers, and one is already in M8, so they set the other one for today that was set for arraignment today with the same case.
Okay, can the clerk give me the case number that's already in M8?
Okay, the one that's already in name is 25 MM 9134.
Yes, I see where the public defender's office is appointed on that. It's already in the
Yes, ma'am.
M8 division. And this one is going to be, they're doing a request for a CompuVal?
Yes, Your Honor. I mean, yes,
Okay.
ma'am.
This is the state of Florida. Polk County would be the county,
Set for April 9th.
if you will.
Thank
Or
you,
the
Judge, for
city.
letting me get that
No problem.
clarified.
All right. I think the only person we have left in South is Mr. McKinney. As soon as we're done with Mr. McKinney, we'll cut them loose. All right. Moving on to the ladies.
Oh,
First
yeah.
up, we
Your Honor?
have, yeah.
Officer McKinney from the Department of Corrections. On Mr. Barton,
Okay.
Barton, come on down.
Are you ready? Yeah, Mr. Barton's the one that we're waiting on. He has a 15 CF case here in Polk County, but my documents show that he has a warrantless VOP out of Osceola for burglary and grand theft, but he's under the belief that he did straight time and no longer on probation.
Right.
he did have probation in Osceola, but it has expired and is terminated long ago. So if there's a hold for Osceola, it is not for a VOP.
Damn, he wasn't lying. He was right.
The judge yesterday, Your Honor, said she didn't see where this even is, like, anywhere.
Who would have ever thunk it?
Up, or she was going to dismiss it. I believe that's what she said.
She don't get to dismiss it. She just gets to would let you out of jail.
I may have understood it a little wrong,
Yeah, I know
so I apologize.
No, I kind of understand what you were saying, but just wanted to be clear that, yeah, she wouldn't get to dismiss it. She would just get to let you out of jail.
Yes, sir.
I'm just trying to find your stuff, Mr. Barton.
Thank you, sir. Sorry.
And Your Honor, I am showing on the first appearance hearing docket from yesterday. No PC was found on counts 1, 2, and 3. PC was found on count 4, and the state had 24 hours to give more information on 1, 2, and 3.
What up, Jake?
Excuse me. 1 and 2 are the VOP for Osceola, which he is not on for Osceola. 10 or 3, however, is the same case number as count 4, which is the Polk VOP. So I'm not sure why there's no PC on one count, but there is on the other.
Yeah, the funny thing is I've been here 7 of the last 9 days, but yesterday wasn't one of them. And I don't even know what count 4 was. Is it a grand theft possibly?
Yes, Your Honor, that's the VOP for grand theft.
Yeah, and so Ms. McKinney, would you agree that on that 15 CF 3588 out of Polk County, that he is currently on probation for both a grand theft and a burglary?
Hey, what up, Steelers?
Yes, he is, Your Honor.
Yeah, and I think that she got it right and wrong. And by that, I mean, Mr. Barton, you're not on probation. Mr. McKinney confirmed out of Osceola. So I'm going to find no probable cause and you'll be ROR'd on the Osceola matters. But you are on probation for the Polk County case, not 1 count, but 2 charges, burglary and grand theft. And I'm looking at your affidavit, and the affidavit's alleging that you refused to submit to a urine test. So that is the basis for the warrantless BOP. So I'm going to find probable cause and hold you on both the grand theft BOP and the burglary BOP in 15 CF 3588. I'll appoint the public defender if you want them. And I think you said you did. So I'll appoint them. And I can tell you that you're going to go see a judge here in Polk County on April 27th. Okay. Have a great day, sir.
Can you ask the public defender to please come see me before that date, please? Because I have some information for them.
Some
I won't
information.
ask her, but I can tell you that she's looking at me because she hears what you're saying. So she can make some notes. Yeah. So she heard you.
Okay.
Yes.
Thank you.
I can assure you, it will not be I, but there will be a lawyer who will see you before the violation of probation hearing, okay?
Okay. Yes, ma'am.
You'll be able to give them the information that you need to give them.
All right. Thank you very much. Thank you, Your
Yes.
Honor, for your help and time.
No problem, sir. Have a great day. All right. I think we're on to the ladies. If I remember, Cheyenne Babb.
Yes, sir.
Ms. Babb, you're here for possession of marijuana, possession of paraphernalia. Do you want me to appoint the public defender?
Sure.
All right, I'll go ahead and appoint that office to represent you. Ms. Babb, I'm finding probable cause for those 2 charges, and I'm setting your bond at $2,500 per count, 5,000 total. Have a great day.
Thank you.
That brings us to Charlene Cintron.
Good afternoon, Judge.
Good afternoon, ma'am. You're charged with violating your probation. What puts you on probation are possession of meth, possession of paraphernalia. Do you want the public defender?
Yes, sir.
I'll appoint the public defender. Looked over a warrant signed on the 8th of July by Judge Dirt. It was 24, so you've been away a while. He's retired now. He ain't working anymore. So I'm finding probable cause, holding you no bond. You'll go see his replacement on the 28th of April. Have a great day, ma'am.
You too.
This one. Central.
We are up to Kalia Collins.
All right, here we go.
Ms. Collins, you are charged with a new charge of domestic battery, and you have a warrantless VOP for grand theft. Do you want the public defender on both of these?
What up, Just a Ghost?
Yes, sir.
All right, I'll go ahead and appoint the public defender on each. Looked over your paperwork, finding probable cause. Finding probable cause for the domestic battery, going to set your bond at $5,000, making it a condition of pretrial release. If you post that bond, please check in with pretrial release immediately. Sign up with them in person, calling them on Thursdays. You have all the standard conditions plus special conditions 16 and 17, which says you can't possess weapons, firearms, or ammunition. You can't have any intentional contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim as well as the victim's home, vehicle, place of employment, or school they attend. And I will hold you no bond on the VOP. Have a great day, ma'am. Marissa Folds. Ms.
Hey, what up,
Folds,
Em?
Good afternoon. You're charged with trespass. Do you want the public defender?
Francis? Yes,
Free
sir.
inspections?
With the public defender, finding probable cause, setting your bond at $250. Have a great day.
That's a pretty low bond for Florida.
Naya Francis is charged with a warrant out of another jurisdiction for failing to appear on the charge of battery. Looks like she's a bring back. Ms. Goins, what can you tell me? Has she been here a while?
Yes, and the last name again, I know,
Francis.
yeah, I remember the Naya name.
Yeah.
It's Francis, yeah.
I can tell you the date of
She
the
was-
affidavit looks like it's probably about a week ago. I
She
think.
was brought back from, March 27th. And so,
I've been here for 3 months, so.
Yeah.
right. Well, and there may have been another, I don't know if there's a current, a local case pending, but I do recall that she has also had previous times when she's been set. But the question is, you have a current, which is you have a Polk County case that was pending.
I'm already let go from that case.
That may be, okay.
It was
that's-
time served. Yeah, it was time served, ma'am.
Okay, Mr. Francis, allow me to converse with the court, okay? I'm trying to sort things out for you. Okay?
Okay.
Shut your mouth. No, I for
I
sure
recall
it's
last week when-
it's definitely
when
cold
I
in
was
there.
First appearance on the 27th, that there was discussion about the fact that she'd been here longer. But I'm saying generally, we don't have people sitting for 3 months. There may have been a pending local case that resolved itself, and therefore now she's ready to go back to Hillsborough. So the question becomes, when was the other case resolved? And that would show how long she'd been waiting to go.
Polk County,
Can the court answer
Florida
that?
court.
Sure, it has to be dated one month, I guess.
What?
At least in our system, I'm sure this go dated 27.
Okay.
It's the last week.
Okay, so actually the case, the Polk County case that was pending was resolved at least on or by March 27th of this year.
That's what I'm seeing. The concerning part is Hillsborough County. I
Yes,
bet they have a bus that goes between Tampa and Bartow multiple times a day.
that is correct.
So.
What up, Cha-Cha?
It's not like we're talking about the Keys or Pensacola here. We're talking about Hillsborough.
Damn, they bringing more people in.
Ms. Francis, I would ask the court.
Damn,
release
welcome
her
to the
on
party.
Hillsborough County case, and then she can go and avail herself of the Hillsborough County authorities.
What says the state?
Our state would request just one more week just to allow Hillsborough time. Yeah.
I mean,
Party bus.
candidly, I mean, it just creates more work. I feel like, not to, my soapbox, but been doing first appearance for many years now. I don't remember it being this many bringbacks from counties that aren't. I mean, we went through COVID and we knew, people weren't going to be moved a whole lot, but now we got past all of that. People should be picked up a lot quicker. That's my humble opinion. It just seems like it creates a lot of work for all of us. And I think that's probably a reason why first appearances, even though we're growing as a population, our first appearance docket's as large as it's ever been, and a lot of it's bringbacks. My God, I got a whole page of bringbacks because people aren't coming to get their inmates from Hillsborough County. So here's what I'm going to do. Ma'am, this is a misdemeanor. You've been in our jail for a week now, waiting for the county next door to come get you. I'm going to order that if you're not picked up by 5 o'clock
Thank you.
on April the 9th, that you should be released from the Polk County Jail. Okay?
Another week?
I'll give them one more week to come get you. But yeah, if you're not picked up by 4/9 at 5 p.m., I'll order that you release. Now, your case doesn't go away. They're still going to probably keep looking for you. So it might not be a bad idea if you get out at 5 o'clock next Thursday, to call over there and say, hey, when's my court date? I need to get back in front of you guys so y'all don't keep looking for me. But if you're still here a week from today, which I don't know why you would be from Hillsborough County, then they'll release you at 5 o'clock. Have a great day.
No, screw that.
Tabitha Hancock?
Yes, sir.
Hancock, you're here for domestic violence battery. You want me to appoint the public defender to represent you?
Yes, Your Honor.
I'll appoint the public defender. I've looked over your paperwork. I'm finding probable cause, setting your bond at $2,000, making it a condition of pretrial release. If you post that bond, you must immediately check in with pretrial, sign up in person, calling them on Thursdays. You have all the standard conditions plus the following special conditions. You're not allowed to use, possess, or carry firearms, guns, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly through a third party. Stay 500 feet away from the victim as well as the victim's home, vehicles, place of employment, and school they attend. And because you live with the victim prior to being arrested, you get to return there one time within 48 hours with the police to retrieve your essential items like medicine and clothing. Have a nice day, ma'am. Victoria Harden.
I can't ask her a question.
Yes, sir.
Ms. Harden, you're charged with a warrantless VOP. You look like you're a bring back as well. And is this from?
It's
So this was not an Allen County warrantless VOP.
No, this was Polk County, and the probation officer, I've had false positives on my psych meds before for this.
Psych meds?
So they're
Positives?
just waiting for it to come back from the lab. Nobody expects it to be positive. A
All right,
62-year-old.
62?
No, I didn't mean to cut you off. I just know
Okay.
that we probably should try not to talk about it. And when I was,
Okay.
the whole bring back thing is between me and the attorneys. I know that's something you shouldn't have to worry about.
Yes,
But I was
sir.
just commenting that you were brought back from a previous court date. I was just making sure it wasn't a week ago from, like some others I talked to. So you just happened to be not available yesterday when court was going on, so they brought you back today.
Yes.
So you're here for a warrantless VOP on a grand theft charge. Do you want the public defender?
I do.
All right, I'll appoint them to represent you. I've looked at the affidavit from the sheriff's department, and to your point, and don't comment, but they're saying that you tested positive for fentanyl.
Fentanyl?
Probation officers.
Yes, sir.
I'm gonna find trouble. I hear what you're saying. I understand.
Okay, okay.
So, but yeah, it's positive for fentanyl. So I'm going to hold you no bond, and we're going to send you to see the judge on 4/28. Have a great day, ma'am.
Okay. Can I come back tomorrow after I speak to a public defender? I didn't get. Okay, I'm sorry.
Yeah, no, ma'am. You'll have the public defender. You just don't come back to first appearances.
Okay.
Destiny Henry is a fugitive from justice from the state of Texas. Ma'am, do you want the public defender appointed to help you on your extradition back to Texas?
Yes, sir. My kids are down here.
Okay. Well, I mean, as long as they're being taken care of, there's nothing for me to do. But if you're saying, Judge, nobody's watching my minor children, well, if that's what you're saying, then I'm going to go back to my office and call DCF, Department of Children and Families, to
That
get
was
them
the whole-
involved because I don't want them to be in danger.
Yes, sir. And that was the whole thing.
Yes.
Oh, never mind.
Edward Goins from the Public Defender's Office.
Ah.
I had just noticed in reading the affidavit that I believe that this young woman's sister is taking care of the children, so they are not endangered in any way at this point. I am just sure she wants to find out when she's going to be able to get out of jail, but I know the court is going to set a hearing for the fugitive hearing on the extradition issue.
Sure.
For a short, which should be held shortly.
The 7th.
On the 7th.
Yeah.
Okay, so the next court date is the 7th.
So ma'am, I'll appoint the public defender. The Texas judge, once you held no bond, will hold you no bond. But as Ms. Goins said, we'll send you to see a circuit judge here real quick, and that'll be 5 days from now on the 7th. Have a great
Yes,
day,
sir.
ma'am.
Yes, sir. And how long do it take them to come get me?
That's between you and the circuit judge, and depends on whether you agree to it or not. A lot of factors. Have a great day,
Because I
ma'am.
really don't want to get expedited. I want to stay in my, request to speak to the judge.
Oh, you can request to sit down.
Sir, I'm not
All right.
doing it.
Cherie Martinez.
Yes, sir.
Ms. Martinez, you're charged with burglary with an assault or a battery. Now, that is a first-degree felony, punishable by life in prison.
Damn, life.
Now, all kidding aside, if that young woman, I don't remember her name, if she clearly wants to talk to me, if she keeps disrupting court, she'll be talking to me, but it'll be a contempt hearing because I'm having a hard time conducting court, but she's back there screaming at you guys. So unless she wants to come talk to me and explain why I shouldn't hold her in contempt, I would encourage her to be quiet. All right. All right, Ms. Martinez, you're charged with burglary with a battery or an assault. Do you want the public defender?
I knew.
All right, so I see you saying yes. I heard you say yes. I'll appoint the public defender. I'm finding probable cause. What says the state?
Your Honor, at this time, because this is a first degree felony, punishable by life, state is requesting a defendant held no bond.
All right. Have you prepared a motion for pretrial detention or
No, Your Honor, because this is a conveyance and not a dwelling, it does not qualify for a pretrial detention motion.
She burglarized a home. So in Florida, if you burglarize a home, that you're potentially looking at life.
I'm asking that the court not impose a zero bond for, in this case, this was the burglary was associated with a conveyance, and I read the probable cause statement, so I know what at least what the allegations are. But under these circumstances, it just seems like at some point you can't hold everybody at zero bond.
Yeah, you can.
Even though, because of the level of the offense, it could be allowed by law.
Sure.
And I do believe the court has some discretion. So I'm asking that the court.
I think the issue is
at zero bond, but the court can set a bond.
if you burglarize a house and there's somebody in the house and then you assault them, it changes the penalty, if you will.
Jumps off the page at me there.
They're definitely going to penalize her, if you will. I wouldn't dream of running into somebody's house. That's crazy. Especially with Florida. Florida has stand your ground laws. They could just let you have it, leave you right there, nice and cold on the floor of their house, and that's it. It's game over. Definitely wild for doing something like that.
We've had no reason to go over this before. I've made my feelings known as far as how. So I'm not going to hold her no bond, but I do want to give her an appropriate bond. So do you have a recommendation as to? And again, reasonable people can disagree on appropriate, but I just want to know what your position is on what a bond should be, knowing that you originally wanted none, but I'm telling you, I'm going to give her a bond.
Time Your Honor, so would request a $50,000 bond with pretrial release conditions.
Ms. Goins, any?
Did the state say 50,000?
50,000.
Okay.
I think your comma's in the wrong place.
Talking about bonds and to be set.
But I'm no mathematician, if you will.
Under the circumstances, I would suggest to the court 10,000, 15,000, but 50,000 is it just doesn't seem appropriate in this case.
So if he doesn't take it out.
Doesn't condone what's alleged here. It isn't a matter of that. It's a matter of this person showing up for court and whether they'd be a danger to the community. And I don't think that that's the case.
No,
Hey, thank you.
I'm not going to hold you no bond. Candidly, I could. I had the, I don't have unlimited power, but I have discretion. And here for that charge, I could have held you no bond. I don't care how rich you are, you couldn't get out of jail. But I'm going to give you a bond. But it's going to be a high bond. I'm going to set your bond at $50,000. Going to make that bond a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial release services. Call that office on Tuesdays and Thursdays. You have all the conditions everyone else has, plus the following special conditions. You are not allowed to have in your possession any firearms, weapons, ammunition, or knives. You are not allowed to have any, and this is important, okay? You can't have any intentional contact with a listed victim that appears on your affidavit. This means directly, indirectly, in person, by writing, by telephone, pager, fax, texting, email, social media. You got to stay 500 feet away from
Thanks, Hector.
that woman, her home, her vehicles, where she works or where she goes to school. Okay?
Yes, sir.
Have contact with her that's intentional, you're gonna find yourself right back here and you might not be getting a bond then. All right, have a nice day, ma'am. That brings us to Nasia Oldenburg. Ms. Oldenburg, you're charged with domestic battery. Do you want the public defender?
Yes, please.
I'll appoint the public defender, finding probable cause, setting your bond at 2,000. Now, she was a bringback. I'm guessing she just wasn't available yesterday.
Yes, and yesterday,
Just wanted
she-
to clarify.
they thought she might have been in the hospital.
Okay,
Or
just wanted to make sure there was nothing more to it than she just couldn't be here yesterday. So ma'am, probable cause, 2,000 is your bond. Condition of pretrial release. If you bond out, check in with pretrial, sign up in person, calling them on Thursdays. All the standard conditions plus special conditions 16 and 17, which is you can't have weapons or firearms in your possession, and you can't have any intentional contact with the victim. Stay 500 feet away from the victim, as well as the victim's home, vehicles, place of employment. Have a nice day. Tremaine Parker.
Hey, Judge.
Good afternoon, ma'am.
Good
You're
afternoon.
charged with robbery. Robbery, they made a point to say it's not with a firearm, so it's just
Strong
F2
arm?
robbery.
Yes, sir.
Punishable up to 15 years in prison. Do you want me to appoint the public defender?
Yes.
I'll appoint the public defender to represent you. Ms. Parker, another judge has already reviewed your affidavit and has already signed an arrest warrant. That was Judge Franklin. She signed it yesterday. So I find probable cause just like she did. And she wants, I'm going to set your bond at $15,000. She wants that bond to be a condition of pretrial release. So if you're able to post that bond, you must immediately check in with pretrial services. Call that office on Tuesdays and Thursdays. You have all the standard conditions plus the following special conditions. 13 says you cannot possess or consume. No, actually, that was the deputy wanted that, but the officer. So I'm not going to do 13. I am going to do 15 plus Judge Franklin wanted you to have a curfew of 10 p.m. to 6 a.m. So you'll have to be in your approved residence between those times.
Okay.
So condition 16 says you can't have any weapons, firearms, ammunition, or knives in your possession, and you're not allowed to have any intentional contact with the alleged victim. This means directly, indirectly, through a third party. You must stay 500 feet away from the victim as well as his home, vehicles, place of employment, and any school that he attends. Have a great day, ma'am.
Okay, sir, how much is that in cash?
$15,000.
So I gotta pay $1,500 to get out?
That's between you and the bondsman, but the bondsman, I've been told they want 10%. But again, that's between you guys. I don't know.
Up
Have a good
next is going to be the motor mouth, if you will.
That brings us to Melanie Rogan. Is this the one you mentioned to me? Miss Rogan, you're charged with possession of cannabis, possession of drug paraphernalia, and possession of a prescription drug without a prescription. Do you want the public defender?
Yes, sir.
I'll appoint them to represent you.
Thank you.
Ma'am, I've looked over your paperwork. I find probable cause after I've read it. Going to set your bond at 1,000 on the cannabis, 1,000 on the paraphernalia, and 250 on the prescription drug without a prescription. Have a nice day.
Thank you.
Yeah, next up is Stevens. Ma'am, you are charged with possession of paraphernalia, possession of cocaine, 2 counts of possession of methamphetamine, 1 count of possession of fentanyl, and 1 count of knowingly driving while license suspended with a prior conviction. Do you want the public defender?
Yes.
Did somebody say soccer mom?
I'll appoint the public defender to represent you.
What up, Maria?
Just had to point out that the 2 counts of meth is unusual, but I looked at the affidavit and it does appear to be 2 different substances, not just 2 different meth in two different locations. It's two different, distinctly different substances that supports it. So ma'am, I find probable cause for all these charges. Your bond on the paraphernalia is $1,000, it's $5,000 on the cocaine, $5,000 for each of the meth counts, $5,000 on the fentanyl, and $250 on the knowingly driving while license suspended or revoked. Have a nice day. That brings us to Erica Warnock.
Yes, sir.
Warnock, you're charged with possession of paraphernalia, possession of methamphetamine, and possession of cannabis. Do you want the public defender?
Yes, please.
I want the public defender. Finding probable cause, setting your bond on the paraphernalia at $2,000, on the cannabis $2,000, on the meth $6,000, for a grand total of $10,000. Making those bonds conditions, actually I take that back, no pretrial release, but instead I'm going to take you into custody on what we call Parker versus State. You're currently out on bond and pretrial on a misdemeanor charge contained in 25 MM 8863. So I am going to take you into custody pursuant to that Parker versus State, hold you no bond, and send you to see the judge in that division. Do you have a public defender already on that misdemeanor older case?
I have regional counsel.
Okay, just wanted to make sure you had somebody, a attorney representing you. Have a nice day, ma'am.
Hey, just giving you guys a heads up. I gotta leave
Michelle
now.
Wilkerson.
But if you guys want to continue watching, jump on over to YT, add collect call from. I'm gonna leave the stream running. Add collect call from on YouTube, if you will. With that being said, I'm out.
The new charges are burglary of a dwelling and criminal mischief. You also are here before a violation of probation on two charges, battery on a Leo and another third-degree felony. Do you want me to appoint the public defender to represent you?
Yes, sir.
All right, I'll appoint the public defender to represent you. Ma'am, on the new charges, I'm looking at the capias right here in front of me, as well as the information. Finding probable cause, your bond on the burglary of a dwelling will be $15,000. Your bond on the criminal mischief is $250,000. I'm also looking at a warrant that was signed by a circuit judge for your VOPs. It looks like that was signed on, wow, August the 8th of 2023. That's an age on it. So I find probable cause, holding you no bond on the two VOPs. Have a great day, ma'am.
Thank you.
And the last female is Shantae Alexis Williams, who's here for 3 warrantless VOPs, all contained in 23 CF 8100. Ma'am, do you want the public defender?
Yes.
I'll appoint them. I'm finding probable cause. It looks like the probation officer is alleging that you have 3.5 grams of THC and 176 pills of oxycodone.
Whoa.
So I'm finding probable cause, holding you no bond. You'll go see that judge on April the 28th. Have a nice day.
Oh, no one.
All right, on to the gentleman. Good.
All right, guys. I appreciate you
We are up
guys.
to Richard Ayabarino.
But I gotta go. All right. I'll see you guys on the next one. I'm gonna leave the stream up for you guys.
Richard Ayabarino is charged with 2 warrants out of Orange County for ag assault and battery, domestic violence. Sir, I cannot appoint the public defender, but you can always hire a lawyer or wait till you get back to Orange and ask for the public defender. Finding probable cause based upon the paperwork I have here in front of me. The judge over in Orange wants you held no bond. We'll hold you no bond and alert them that you're ready for pickup. If you're still here a week from today, we'll bring you back so we can talk about it. Have a great day.
Your Honor, may I address the court?
Go right ahead. Just don't talk about the kickbacks of your case.
Yeah, I'm not, what I want to say is, once I was made aware of the warrant, I turned myself in. Is it possible to set bond with the condition of turning myself into Orange County in 24
sir.
hours? No?
Yes, sir.
Okay.
No, I can't. I'm choosing not to do that. Candidly, the warrant was in Orange County. You certainly could have gone to Orange County and turned yourself in Orlando. It might have sped the process up a little bit, but you
I have
chose
no
to.
idea. I have no idea.
Just so you know, yeah, in the future, when you've got a warrant from this county, but you happen to live or reside in another county. Yeah, the warrant's in Orange. Hop in the car, get yourself over there. It'll just speed up the process of you getting in front of that judge over there. Just something to tuck away in the back of your head. Have a great day, sir. Andrew Binky. Sir, you're charged with knowingly driving while your license is suspended. It's a first conviction or first allegation. Do you want the public defender?
No, Your Honor. I did not know I had a expired or suspended license.
Okay, you're in luck because you're innocent till proven guilty and the state has to prove you did know. I just want to know, do you want me to appoint the public defender?
No, that's all right. Either
Okay.
way, I'm fine. But I do request that, I could be released on my own recognizance so that I could go and take care of the situation as fast as possible, as I have 2 classes to teach on Monday at college. So I'd like to try and get everything taken care of before my next court date so I can, have everything in a row.
Have a quick look here, the Auburndale PD affidavit. All right, sir. Finding probable cause. I'm not going to ROR you, and you haven't been recommended for straight pretrial release, but I'll set the bond pretty low, about the lowest you'll see around here, which is $250. Have a great day, sir.
Thank you.
You bet. Joshua Bradley is charged with domestic violence battery. Do you want the public defender?
Yes, sir.
I'll appoint the public defender. I reviewed the paperwork, finding probable cause. I'm going to set your bond at $2,500 and make it a condition of pretrial release. So if you post that bond, you must immediately check in with pretrial, sign up in person, and call that office on Thursdays. All the standard conditions plus the following special conditions. Based upon the allegations, I'm going to order that you not possess or consume alcohol. Can't go to bars, nightclubs, or lounges. You'll be subject to random urinalysis that tests for alcohol. In addition to that, you're not allowed to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. And lastly, based upon the victim's wishes, I will allow you to have contact with the victim, but this contact is prohibited from being physically or verbally threatening. You're not allowed to be violent or abusive in any manner whatsoever. We call that peaceful contact. Have a great day, sir.
Yes, sir. Thank you.
You bet. Bruce Bradshaw. Mr. Bradshaw, you're charged with possession of synthetic cannabis,
Yes, sir.
possession of drug paraphernalia, and tampering with physical evidence. Do you want the public defender?
Yes, sir.
I'll appoint them to represent you. I've looked over your paperwork. Your allegations were a little while ago because they sent your stuff off to testing ahead of time. So
Yes,
that
sir.
being said, I'm just acknowledging that I find probable cause. Your bond on the tampering is $5,000. It's also $5,000 on the synthetic cannabis and $1,000 on the paraphernalia. Have a great day.
How can I have my court date?
Sure, it looks like it's May 5. They're in circuit court. That brings us to Johan Cavalhan. Sir, you're charged with 2 counts of burglary of a occupied structure and 2 counts of grand theft. You want me to appoint the public defender to represent you?
Last time you said it was petty theft.
Well, I'm just telling you what you're charged with. I'm not, got the affidavit here and it's charged with 2 counts of burglary and 2 counts of grand theft. So we can talk about it more. I just want to know, do you want the public defender?
Yes, sir.
Okay.
But what I steal is it? I got money. What I steal?
Hold tight and please don't talk about the facts of your case. So interesting he brought that up, and I think I have talked to him at first appearance before. This is a lengthy affidavit with a lot of duplication, but I just zeroed in on the one area that says, the total value of stolen property between the two incidents is estimated at $800. So I understand you can.
You said it was $100 last time, huh?
Hold on a minute, okay? I'm talking to these folks, okay? And you're not making it easier for me to do that.
All right. I
So,
understand.
yeah, and just hold tight. So I understand you can lump stuff together from separate thefts to get to a grand theft. I just don't think you can lump things together from two thefts from a Chick-fil-A, two separate, instances, and those lumping them together supports two grand thefts. So if you read this differently, just let me know, but.
Yeah, I read it similarly, Your Honor. I think that there are certain probable cause on count.
I agree. Yeah, I just wanted to run it by you to see if I had misread it. So, sir, you kind of found out from what I was just saying there to the attorney for the state that the allegation is that you stole 2 cash safes from the Chick-fil-A in Lakeland. Yeah, like I said, I wasn't there because I can't tell you if it was true or not. I'm just telling you that that's what the allegation is. I find probable cause for the 2 burglaries and 1 count of grand theft. I'm not going to find probable cause for the second count. I just don't believe it's, I believe that the alleged $800 would support 1, but not 2. So on that second count, you'll be ROR'd. As far as his record, would you characterize his as none, slight, or extensive?
Extensive.
Extensive.
It was previously placed on pretrial for the penny that charged regularly, and those were his 2 conditions that you gave him.
So on the previous, so now I'm just confused. So when you said it previously put him on there for petty theft, but it was, so he's on pretrial for a totally separate charges. I know we had conversations. Predates target. And I know we had a colorful discussion the other day about the target. All right, sir. So you're not Parker eligible because these right here took a while for them to arrest you. But in the meantime, you saw me on the other charges the other day on the target cases. So what I'm going to do is I believe enhanced bonds are appropriate. I'm going to set your bond at $7,500 on the burglary, the second count of burglary, and the grand theft. I'm going to make those bonds conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial. Call in on Monday, Wednesday, and Friday. And you have all the standard conditions plus the following special conditions. You're not allowed to have any intentional contact with the Chick-fil-A's, not just the one that they're accusing you of stealing from, but any of them. You already know from the other day you can't have any contact with Target, so now you have to stay away from both Chick-fil-A and Target. You also have to stay 500 feet away from the event location. Have a nice day, sir.
Thanks.
You bet. Chick-fil-A's is good. Don't even stay away from the Chick-fil-A's and, of course, earlier the Targets. Juan Chaparro is charged with grand theft, burglary, and possession of a controlled substance without a prescription. Sir, do you want the public defender?
Yes, sir.
All right, I'll appoint the public defender. Just to be clear, the grand theft, that's a 3rd-degree felony. The controlled substance, they're alleging it's a certain schedule, so it is a 3rd-degree felony as well. But the big one is the burglary of an occupied structure. That's a M2 punishable up to F2 punishable up to 15 years in prison. I'm finding probable cause for all 3 because Judge Denmark has already signed your search warrant yesterday. So I'm finding probable cause like she did. Want to set your bond at $5,000 on the grand theft, $5,000 on the possession of a controlled substance, and $15,000 on the burglary. Those bonds are going to be conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays. All the standard conditions plus special condition 16 and 17, which says you can't have weapons or firearms in your possession, and you cannot have any intentional contact with the victim. Stay 500 feet away from the victim as well as the victim's home. vehicles they drive, their place of employment, or any school they attend. Have a great day, sir.
Can I ask you a question, Your Honor?
Second, sir, if you don't mind. 15 for the burglary, 5 for the other 2. Yes, sir, go right ahead. Just don't talk about the case, okay?
No, I wasn't. I was just gonna say that, as when I found out that I had the warrant, I came down to Barstow Court and I turned myself in. If there's any way that any of them bonds could be reduced a little,
Well,
because they didn't pick me up. I turned myself in the exact date that the warrant was issued.
yes, sir, I commend you for that, but the bonds, like I said, 2 of the 3 were already set by Judge Denmark, and I certainly don't want to tamper with those.
Okay.
And as much as anything I do here, I'm not going to be your judge, most likely, because yours are felonies and I don't typically do felonies. So you're going to go see a judge, maybe it's Judge Denmark, but you also, before then, your attorney can file any motions they want. And Judge Denmark, who's going to preside, or whatever circuit judge, can readdress the bonds. But for today, I think they're good where they're at. Have a great day, sir.
Thank you, sir.
You bet. Jameson Cranfield. Mr. Cranfield, you're charged with domestic battery. Do you want the public defender?
Yes, Your Honor.
I'll appoint them to represent you. Mr. Cranfield, I've looked over your paperwork from Bartow PD. I find probable cause, setting your bond at $5,000, making it a condition of pretrial release. Sign up in person with that office after you get out of jail. Call them on Thursdays while your case is pending. All the standard conditions plus special conditions. 13, which says you can't possess or consume alcohol. You can't go to bars, nightclubs, or lounges. You'll be subject to random urinalysis that tests you for alcohol, excuse me. You're not allowed to have any weapons or firearms while you're on pretrial release, and you're not allowed to have any intentional contact. I'm sorry, take that back. I'm not going to do 17, I'm going to do 20, which says you are allowed, this is based upon the victim's wishes, you are allowed to have contact with the victim, but that contact is prohibited from being physically or verbally threatening, no violence or abuse in any manner whatsoever. So you do get to have contact with the victim. You do get to go home. It's got to be peaceful contact, and you got to quit drinking. Have a great day, sir.
Thank you, Your Honor.
Got Dwayne Dalton. Mr. Dalton, you're charged with battery. It's a form of domestic battery based upon dating, repeat, or sexual violence. You want the public defender?
Yes, sir.
Want the public defender to represent you. Sir, I find probable cause based upon the affidavit that I reviewed from the sheriff. To set your bond at $5,000. Make that bond a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services. Sign up with them, calling them on Thursdays. You have all the standard conditions that everybody has, plus special conditions 16 and 17, which says you can't have weapons or firearms, and you can't have any intentional contact with the victim. Stay 500 feet away from the victim, as well as the victim's home, vehicle, and place of employment. Now, I can see that you have an open felony case. So what I'm going to do is, since you were out on bond on that, you picked up this new charge, I am going to revoke your bond on 25 CF 10694 and hold you no bond pursuant to the authority of Parker versus State. And I will appoint the public defender if you don't already have a lawyer representing you on that charge, that felony charge. Have a great day, sir. Jonathan Escorianza. Sir, you're here based upon warrants out of Broward down there in Fort Lauderdale area. The warrants are for burglary of a dwelling and petty theft. I can't give you a public defender here, but you can always hire a lawyer or ask for the public defender when you get back down there. I've looked over your paperwork. I find probable cause. The judge in Broward set your bond on the petty theft at $500. But before you rush off to post bond on that, just know that the judge in Broward wants you held no bond on the burglary of a dwelling. So it'll be no bond on the burg dwelling, 500 on the petty theft. We'll notify Broward that you're available for pickup. And if for some reason you're still here on the 9th of April, we'll bring you back so you can talk it over with the judge. Have a great day. Malcolm.
Can I say something real quick? I'm sorry, Judge.
Yeah, go right ahead.
I was never even aware I had this case because I never got arrested for it or anything.
And then
Okay, sir.
I have
And
gotten
I
pulled
don't-
over and the police never said I had a warrant. And I haven't been down there since the time of when this supposedly happened.
Okay. Good luck to you, sir. Step to your left.
Oh.
Mr. Everett, you're charged with 6 warrantless VOPs. The warrantless VOPs are for possession of MDMA, possession of a controlled substance, possession of marijuana known as cannabis, possession of drug paraphernalia, DUI, and driving while license suspended. Do you want the public defender?
I'm gonna try to hire a paid attorney.
Not a problem. We'll make that note of that. And if you change your mind, you can always ask for the public defender later. Looking over your probation officer's short affidavit, it looks like they alleged that you tested positive for cocaine. So I'm going to find probable cause, going to hold you no bond. We'll send you to see that circuit judge on the 28th of April. Have a great day. Next up is Brian Holyfield. He's in charge with possession of meth and possession of drug paraphernalia. Do you want the public defender?
Yes.
I'd like the public defender to represent you. Mr. Holyfield, I've looked over the paperwork. I find probable cause. Now, this open case is a misdemeanor. Is this not a Parker eligible? It's a summons maybe, or? Yeah, I know.
I don't know what you're talking about, sir.
I'm talking to these folks. You got an open case. It's 25 MM 5758. It's closed, so it's not open. Okay. So you had one, but it's no longer open. All right, sir. Finding probable cause, setting your bond at 1,000 on the paraphernalia, 5,000 on the meth. Have a great day. Michael Holmes. Mr. Holmes is charged with dealing in stolen property and grand theft from a dwelling. Do you want the public defender?
Yes.
I'll appoint the public defender to represent you, sir. I have looked over your paperwork, specifically the affidavit for the Bartow Police Department. I find probable cause. I'm going to set your bond on the dealing in stolen property at $10,000. On the grand theft, it'll be $5,000. Making those bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with the pretrial services. Call that office on Tuesdays and Thursdays. All the standard conditions plus the following special conditions. You're not allowed to have any intentional contact with the victim, directly, indirectly, or through a third party. Stay 500 feet away from the victim, as well as their home, vehicles, place of employment, or school. Now, because I found probable cause and I'm aware that you're on probation on a CF case number, I'm going to go ahead and do it in a stancher warrant, take you into custody on the VOP, hold you no bond on 25 CF 5355, and appoint the public defender to represent you on that matter. Have a great day, sir. William Holton. Mr. Holton, you're charged with criminal use of personal ID that resulted in $50,000 or more in loss, scheme to defraud, $50,000 or more in loss, and grand theft greater than $20,000. Do you want me to appoint the public defender to represent you?
I think I should probably get a private attorney.
Yeah, that's totally up to you. And if you change your mind, you can always ask for the public defender if you're unsuccessful. So we'll make a note that you want to hire your own attorney. So we'll let you do that, of course. I'm looking over a warrant. Judge Franklin is a circuit judge here. She signed your warrant yesterday at 3:02 p.m. So I'm finding probable cause based upon her earlier determination. Going to set your bond on the criminal use of personal ID at $30,000. On the scheme to defraud, $30,000. On the grand theft greater than $20,000, I'll set it at $15,000. $75,000 total, making those bonds conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services, sign up with them, calling them on Tuesdays and Thursdays, all the same standard conditions everyone has, plus special conditions 16, actually special condition 17, and no co-defendant is 23. So basically 17 says you can't have any contact with the victim. stay 500 feet away from the victim, their home, their vehicles, where they work or where they go to school. And Judge Franklin checked off that she wants you to have no contact with a co-defendant, directly or indirectly. Have a great day, sir.
Thank you.
We are up to Jaden Horsey. Sir, you're charged with possession of marijuana over 20 grams. That's a felony. Keeping or maintaining a structure for drug activity. That's a felony. And possession of drug paraphernalia, a misdemeanor. Do you want the public defender?
Yes.
I'll appoint the public defender to represent you.
Your Honor, I have a challenge. I have a statement to make to the court.
Sure. This was a bring back, and the nature of the bring back.
Yesterday, Sandra Smith, the public defender in the courtroom, had made a probable cause challenge based upon the lack of testing for the substances. And this morning I received from the state attorney a revised affidavit that contains the provisions regarding testing. So I know that's what the state attorney, Mr. Nakagawa, was going to point that out to the court, but I acknowledge that we've received it.
Okay.
So at this point, on behalf of Mr. Horsey, there is no additional legal arguments that can be made along the lines of probable cause. And the public defender's office has been appointed, so he'll be able to discuss that further with his attorney.
Sure. Mr. Horsey, we gave him 24 hours as the law allows. They've come up with new additional information. I reviewed it, finding probable cause. Going to set your bond at 5,000 on the marijuana over 20 grams, 5,000 on the keeping or maintaining a structure for drug activity, and 1,000 on the paraphernalia, 11,000 total. So who put him on PTR? I mean, was he, you said?
He was put on pretrial for all of the charges except for the drug issue.
Yeah, no, definitely. I want him on the same. So, sir, whatever charges you had yesterday that you saw the judge for, they put you on pretrial. You're going to be on pretrial for all these charges as well. Makes perfect sense since it was all one event. Have a great day. Trustin Coonsey or Coons. Sir, you're charged with a warrant from F-Corp. F-Corp is like parole. It's Florida Commission on Offender Review. Cannot appoint the public defender, finding probable cause, holding you no bond. These things move pretty quick, so they'll probably be setting up something for you shortly. It might even be remote. Have a great day, sir. If you're here still in custody on the 9th, we'll bring you back to talk it over with the judge. Jerome Lavalley. Mr. Lavalley, you have you're here for VOP, 6 of them in all. Grand theft, burglary, and possession of meth with intent to sell. Do you want the public defender?
Yes, Your Honor.
I'll appoint the public defender to represent you. I've looked over your warrant. It looks like Judge Harb signed it just a couple days ago. Finding probable cause, he wants you held no bond. We'll send you to see him, Judge Harb, that is, on the 20th. Have a great day, sir.
Thank you, Your Honor.
You bet. Aaron Ledford. Mr. Ledford, I think you're a companion of the individual I saw a moment ago. You're charged with possession of paraphernalia, possession of cocaine, 2 counts of possession of meth. Do you want me to appoint the public defender to represent you?
Yes.
I'll appoint the public defender to represent you. Much like her, I've looked over your affidavit, finding probable cause for all 4. It was a little tricky because we don't normally see 2 counts of meth for one interaction, but it does look like these are 2 distinctly separate types of alleged drugs that supports these 2 charges. So I'm going to find probable cause for all 4. On the paraphernalia, it's 1,000. On the remaining 3 charges, they're all felonies. It's 5,000, 16,000 total. Have a great day. Andrew Lockwood is charged with local charge of knowingly driving while license suspended with knowledge, and he has a warrant out of Hillsborough County for failing to appear for court on the same charge. Sir, do you want the public defender appointed to represent you on the local charge?
Yes, sir.
Okay, I'll appoint that office to represent you. looked over the paperwork, finding probable cause, going to set your bond on the knowingly driving locally at $1,000. Going to hold you no bond on the Hillsborough County FTA for the same charge. And as long as you have that local charge, they're not going to call Hillsborough to come get you. But once that local charge, you bond out or it gets resolved, then they'll bring you back to see a judge like me to say, all right, we're going to notify them. We'll keep an eye on you. But right now, as long as you got the local charge, they're not going to come and get you. Have a great day, sir.
So I cannot be bonded out right now?
No, sir. Because, well, you could bond down on the local charge, but you wouldn't go anywhere. What would happen would be you'd come back to see a judge tomorrow and someone like me would say, all right, now that you've bonded out, we're going to call Hillsborough and tell them to come get you. And then we'll sit and wait. And like you've seen some people earlier, a week later, you're back and you're going, Judge, I've been here a week. What's going on? I'll say, well, I don't know why they haven't come to get you, but we'll give them a little more time. So to answer your question, you could on the local charge, but it doesn't mean you're going to be getting out of jail because they're going to be told to come get you.
Okay.
Have a great day, sir. Willie Lott. He's charged with trespass. You want the public defender?
Yes, sir. Yes, sir.
I'll appoint him. Finding probable cause, setting your bond at $1,000. Also going to take you into custody on a Parker on 25 MM 7677.
What's that? What's that?
Actually, it's open, but he's in the M8 division, it looks like. So I'm not going to do that. I take that back. If he's been found incompetent, what I'll do instead, sir, is I'm not going to Parker you, but I am going to leave the bond at $1,000. Have a great day, sir.
Yes, sir. No problem.
Michael Moore. Normally, when they're found incompetent, they discharge the bonds and things ROR. Actually, which ROR is parkerable, but not for an inmate case. I don't want to do it. Michael Moore, you're charged with 5 crimes: resisting without violence, possession of paraphernalia, trafficking in amphetamine, possession of oxycodone, possession of fentanyl. Do you want me to appoint the public defender to represent you?
Yes, sir.
I'll appoint that office to represent you. I've looked over your paperwork. Specifically, I looked over paperwork from the Bartow Police Department, finding probable cause for all the charges. Mr. Nakagawa, would the state like to be heard as it relates to bonds?
Yes, Your Honor. May I approach?
Sure.
Your Honor, this is a motion for pretrial detention as it relates to the trafficking charge. Should Your Honor find this motion to be facially and legally sufficient, the state would request a pretrial detention hearing to be set next Thursday, April 9th at 1 p.m. on the A2 docket. That is done just to facilitate the statutory requirement of the 2 days notice.
Mr. Wins, anything to add about this motion for pretrial detention?
I understand what the state's request is, and that's not the final decision. So at the hearing is when it will be litigated, so that Mr. Moore is aware of that, as far as the zero bond. Is that correct, sir?
Yep. So Mr. Moore, having found probable cause, I'm going to set your bond on the resisting at $1,000. On the paraphernalia, it's $1,000. On the oxycodone, it's $5,000, and it's the same $5,000 for the fentanyl. The big one is the trafficking over 14 grams of amphetamine or methamphetamine. I'm looking at the state's motion for pretrial detention, finding that it's legally, facially sufficient. And it's based upon Florida Rule of Criminal Procedure and Florida statutes. Going to hold you no bond on the trafficking alone and send you to see the circuit judge called the A2 judge on the 9th. So a week from today, you'll go see the circuit judge at 1 p.m. Have a nice day, sir.
Over here.
Fernando Navarrete is charged with domestic violence battery. Do you want the public defender?
Yes.
I'll appoint that office. Finding probable cause, setting your bond at $5,000, making it a condition of pretrial release. If you post that bond, immediately check in with pretrial services. Sign up in person, calling them on Thursdays. You have all the standard conditions plus the following special conditions. You're not allowed to have any weapons, firearms, ammunition, or knives in your possession. You can't have zero contact with the alleged victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim as well as their home, vehicles, place of employment, and school they attend. Because you resided with the victim prior to your arrest, you get to go back there one time within 48 hours. accompanied by the police to retrieve essential items like medicine and clothing. Have a great day, sir.
Right.
That brings us to Harry Pierre, who's been charged with domestic violence, battery by strangulation. Do you want the public defender?
Yes.
I'll appoint that office. I reviewed the Winter Haven PD affidavit finding probable cause. I'm going to set your bond at $5,000. Going to make that bond a condition of pretrial release. If you post those bonds, that bond, you must immediately check in with pretrial services, sign up in person, call them on Thursdays, all the standard conditions everyone else has, plus special conditions 16, 17, 18, which says you can't have weapons or firearms in your possession. You can't have intentional contact with the victim, stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. And you do, because you live with the victim prior to being arrested, you do get to go back one time within 48 hours of your release from custody, if that occurs, accompanied by the police to retrieve your essential things like medicine, clothing, and work tools. Have a great day, sir.
Judge. He says he speaks Creole.
Yes, this is,
Oh, he's the gentleman that decided he wants to.
Yes, Your Honor.
Okay, we don't have a Creole interpreter. I think I've been told that, correct? Yeah, so we'll have to bring, my apologies. We'll bring back Mr. Pierre tomorrow at tomorrow morning. It'll be tomorrow morning with the weekend judge. All right, sir, we'll bring you back tomorrow.
Thank you.
Unfortunate for him because I was going to give him a $5,000 bond, but now he's going to have to stay in on a no bond until tomorrow. All right, have a great day, sir. Christopher Potts. Mr. Potts, you're charged with driving a vehicle without having a driver's license and driving an unregistered vehicle. It's never been registered is what it says. You want me to appoint the public defender?
I guess I didn't know I need an attorney for that, for this, I
Okay,
need one.
I'll appoint the public defender, finding probable cause, setting your bond with an extensive prior history, you're telling me. I think 5,000 per count is appropriate. Have a great day, sir. Travis Rainey? Mr. Rainey, you're charged with driving while license suspended or revoked. They allege that you're a habitual traffic offender and indicate that you're on active federal probation. You
No,
want me to
no.
appoint the- Yeah,
I'm not on federal probation at all. I'm not on probation at all. I've never
Okay.
been to federal.
okay, fair enough. I mean, I wasn't gonna do anything with that. I was just letting you know, that's what they were telling me, is that you're on federal probation. But if you're not, my mistake then. Sir, do you want the public defender for this charge?
Yes.
I'll appoint the public defender to represent you. Looked over the paperwork, finding probable cause, setting your bond at the standard bond for a third-degree felony, which is $5,000. Have a great day. Alexis Ramos?
Good afternoon.
Good afternoon, sir. Mr. Ramos, you're charged with domestic battery. Do you want the public defender?
Yes, please.
I'll appoint that office. I've looked over your sheriff affidavit, or affidavit from the sheriff, finding probable cause for the charge. I'm going to set your bond, taking everything into consideration, at $2,500, making it a condition of pretrial release. If you post that bond, immediately check in with pretrial services, sign up in person with them, calling them on Thursdays, all the standard conditions, plus the following special conditions. You can't have any weapons or firearms in your possession. You can't have any intentional contact with the victim. Stay 500 feet away from the victim, as well as the victim's home and vehicle, where they work, where they go to school. Because you resided, you live with the victim prior to being arrested, I'll let you go back there one time within 48 hours, along with the police, to retrieve your essential items like medicine and clothing. Have a great day, sir.
I have one question, Your Honor.
Sure.
Because we have a son, how can I go about that? Do we just go to court?
Well, candidly, I'm not telling you can't have any contact with your son, just the alleged victim. Now, do y'all have a custody agreement in place by a judge or?
No, no, sir.
I mean, do you have like visitation of any sort with your son?
I'm with him 24/7, sir.
Well, like I said, I don't, I want to keep you away from the mother, you know, that's my goal, is to keep you guys separated. Just so you know, the pretrial services, you know, has tried to reach out to the alleged victim. They left a message, they have not been able to talk to her. You've heard some people today I've allowed to have non-violent contact. Because I haven't heard from the victim, I don't feel comfortable doing that. Ms. Goins, any thoughts on, I mean, they don't have any custody agreement in place. I'm not telling him not to have any contact with his kid, but I understand the realities of the situation. Any thoughts on the matter?
I say that he could have the only contact, and it would have to be nonviolent contact with the mother, would be for the purpose of transferring the child from one parent to the other. I mean, that could be. And looking at the allegations.
What about the input of the victim? You understand, would object to that. That can be something that can be dealt with as a prior provision.
I agree, sir. It's just I'm kind of flying blind here. So again, I'm going to leave it the way it is. Again, I haven't told you you can't have contact with your child. I'm saying you can't have contact with his mother. But whatever I've just done, it could go back and be undone once if you file a motion, and the judge would have more time to listen to both sides or listen to the arguments and make a decision on contact, okay? But for the time being, it needs to be 16, 17, 18. Have a great day, sir.
Thank you.
Arturo Rivera Ocasio. Sir, you are charged with one new crime of driving while license suspended with knowledge and 3 warrantless VOPs. Do you want the public defender?
Yes, sir.
Actually, your VOPs are all out of Osceola County, so let me clarify. The public defender is for the local driving charge, the new one. Those VOPs are out of Osceola, so you're going to have to either hire a lawyer or ask for the public defender back when you get to Kissimmee. But I'll appoint them for the local charge, finding probable cause for all 4 of these matters, setting the bond on the local driving while license suspended at $1,000, holding him no bond on the Osceola VOPs. Have a great day, sir.
Thank you.
You bet. Samuel Rivers.
Rivera.
He's charged with a municipal ordinance of public ordinance against solicitation. And that's out of Winter Haven. Sir, do you want me to appoint a court-appointed attorney to represent you?
Yes, sir.
Appoint an attorney. I'm finding probable cause. I'm going to set your bond on this ordinance at $250. Have a great day.
On the ordinance, Deborah going on behalf of Mr. Rivers. On the ordinance, is that one where Ms. Cheatwood is appointed?
Pretty much on all the ordinances, I appoint Ms. Cheatwood. The way I look at it, they're here. They've been charged with a criminal, one that's subject to incarceration. Because I wouldn't think they'd bring something in front of me that's, you know, civil.
Oh,
So, but yeah, Cheatwood is who I normally appoint on all the standalone ordinances.
Oh, I thought the court appointed the public defender's office. That's what I wanted to clarify.
No, I'm sorry. I kind of just cut straight to the chase. Yeah, Miss Smith has trained me enough to know that I don't appoint you guys on the standalones, but I appointed Miss Cheatwood on for this. Yeah, unless, and if I'm wrong, someone will tell me. As far as that, I know she does all the Lakeland and the counties. I don't know what reason why she wouldn't do Winter Haven as well. Okay, that brings us to Tommy Rucker. Mr. Rucker, you're kind of in the same boat as Mr. Rivers there. You're not here for a state crime, but a municipal ordinance. His was Winter Haven, yours is Lakeland. They say you failed to appear for court over a memorial at the
Yes, sir.
Lakeland courthouse for unlawful camping within the city limits.
Yes, sir.
Do you want me to appoint the public defender? Or actually, in your
Yes.
case, it would be Ms. Cheatwood.
Public defender, sir.
Okay, so I'll appoint Ms. Cheatwood to represent you. Sir, if I give you a court date to show up over in Lakeland to see Judge Flynn there off Memorial and Ingram,
Yes, sir.
do you do it if I let you out of jail?
Yes, sir, I would do it. Yes, sir, I
Kevin, Ms. Dawes, Ms. Dawes is gone. You have a date for me? So he can hear it from the horse's mouth. And I would like
Yes,
for y'all
sir.
under the comments to say, Judge Stamey told him his court date is this date. Because, yeah. So that way, when Judge Flynn, if you're not there, when you tell me you're gonna be there,
Yeah.
he won't do a ROR anymore. He'll do a bond.
Okay, yes. I respect that, sir.
Okay, yeah, I'm gonna let you out of jail, but I just want you to know you want to hear it from me when your court
Okay.
date is.
Okay.
Lakeland court date is going to be 4/29 at 8:30.
So, sir, it's a little ways away, so you're gonna have to write this down. April 29th, and they'll send you something in the mail, assuming your address hasn't changed. What time did y'all say for it? It'll be at 8:30 in the morning, sir. So right there, you know where the courthouse is?
Yeah, I know where it's at.
Yeah, right there off Ingram and Memorial, behind that shopping center, you know, the Buddy Byright
Okay.
used to be a Publix years ago. They called it Searstown when I was a boy, but anyway,
Yes, sir.
Searstown, yeah. If you've been
I
around
know
long
it.
enough, you remember Searstown.
I know where it's at.
So 4/29 at 8:30, you're gonna be released today on your own recognizance, with an agreement that you'll show up on that date at that
Yes,
time.
sir.
Have a good day, sir.
Yes, sir.
Searstown, that's what they used to call it. Because guess what? There was a Sears in the shopping center. Now there's not even any Sears around anymore at all. No. Derek Rutledge. Mr. Rutledge, you're charged with domestic violence battery. Do you want the public defender?
Yes, sir.
I'll appoint him. I've looked over your paperwork from the sheriff. I find probable cause setting your bond at 2,000, making it a condition of pretrial release. If you post that bond, go check in with pretrial, sign up in person, call them on Thursdays, all the standard conditions, plus special conditions 16 and 17. Now, you guys don't live together, so no reason to let y'all go to each other's place to get your stuff. 16 says you can't have weapons or firearms in your possession. And 17 says you can't have any contact with your brother, okay? None. None. Yeah, they said this was your brother that was the alleged victim. So no contact means directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicles, where he works or where he goes to school. Good luck to you, sir.
Can I ask a question? Now, they told me that my sister said I hit her. I wasn't told anything about my brother because my brother pushed me first and I didn't do any, you know, whatever it was, my brother pushed me and I didn't call the cops. So now for whatever reason, now they're saying it's my brother that did this, but they told me it was my sister.
Yes, sir. I mean, I'm not going to read the whole thing to you because you'll, if your attorney
Okay.
demands discovery, you'll get all of this to read at your leisure. But I'll tell you that I read it. I even made some notes, and I will acknowledge that there's an allegation that the wife's got involved too. So there's you and your brother and your wife or your sister. I'm sorry. And there's a lot of people involved. But in the third paragraph, it says, Allison stated Derek pushed Jeffrey and he fell on the couch.
Oh.
At that time,
Yeah.
Jeffrey's wife got in between you two. And then there was a fight that started between the ladies when one of the ladies pushed the other ladies. And then
No
there's a whole lot
problem.
more
Okay.
information. So
Yeah,
just
yeah,
wanted
I
to
get it.
answer your question. Have a great day, sir.
Thank you.
Keon Sok Son is charged with 4 crimes: possession of meth, possession of paraphernalia, resisting without, and domestic battery. Do you want the public defender?
Yes, sir.
I'll appoint that office to represent you. I've looked over your sheriff's office affidavit, finding probable cause, setting your bond at 5,000 on the meth possession, 2,500 on the domestic battery, 1,000 on the resisting without, and 1,000 on the paraphernalia, just under 10,000. I make all these bonds conditions of pretrial release. If you post those bonds, immediately check in with pretrial, sign up in person, call them on Thursdays, all the standard conditions, plus special conditions 16 and 17. You can't have weapons or firearms or ammunition in your possession, and you can't have any intentional contact with the listed victim. Stay 500 feet away from her, her home, her vehicles, where she works or where she goes to school. Have a great day, sir. David Soto Aguiar is charged with having a valid driver's license. You want the public defender, sir?
Yes, sir.
I'll appoint them, finding probable cause, setting your bond at, sir, I'm gonna set your bond at $1,000. And just to let you know, you do have an ICE hold. So there's a hold for you from ICE. So I'm gonna ask the clerks to prepare a detainer for my signature. Have a great day, sir. Angelus Ray Stewart is charged with, Mr. Stewart's charged with possession of cannabis resin. That's a felony, and possession of drug paraphernalia. Sir, do you want the public defender?
Yes, Your Honor.
With the public defender. Looking over your affidavit from the sheriff, finding probable cause, your bond on the felony, the cannabis resin, is 5,000. The bond on the paraphernalia is 1,000. Have a great day.
Your Honor, may I ask a question?
Sure.
Since I'm a first-time offender and I've never been in any trouble, is there any way the bond could be lowered at all?
Well, these are kind of standard bonds, but let me take a look. Does he have any prior record at all? None at all.
No, Your Honor.
Okay, now let's see what your age is. You're born in 06, so you're not an old fella. You ain't had much time to commit crimes, and you're already charged with a felony at age 20. I tell you what I'm going to do. I'll set your bond on the cannabis resin at 2,500. Okay, so that cut that in half. So you're getting a nice benefit. Have a great day, sir.
Thank you,
2,500
Your Honor.
and 1,000 on the paraphernalia. Have a great day. Angel Talavera. Sir, you're charged with resisting without. You want the public defender?
Yes.
I'll appoint that office to represent you. Looking over the affidavit from the sheriff, finding probable cause, setting your bond at $1,000. Have a nice day, sir.
I had a question, sir.
Sure.
Is there any way I could get released today?
If you post $1,000 bond, you can.
Okay, thank you.
But just so you know, the pretrial has told me that you've been in Polk County as a resident all of one day. Normally, when you don't have any ties to Polk County, you usually jack the bond up because you don't have any ties. But I went ahead and left it at the standard bond. So have a great day, sir.
I've been at Polk County for a while.
Okay. Well, they had you down as being. I didn't do that. Have a good day, sir. $1,000 it is. Yeah, that doesn't sound very.
State of residence that day because they don't have any other.
I'd rather it be empty than wrong. You know what I mean? Cedric Webster is charged with possession of meth, possession of paraphernalia. Do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. Sir, I've looked over the sheriff's affidavit, finding probable cause. Your bond on the meth is 5,000. Bond on the paraphernalia is 1. Have a great day, sir. Man, oh man, look at that. Huh? Hang on, just I beat her estimate. Deputy Kimbrough, have a great Easter weekend, and everybody else over there, have a great day.
You too.
It's kind of a